Hello, and we're in a weird setup. Hello, and welcome to Defense Diaries. I am your host, Bob Mata, and this is our continuing coverage of Delphi Unhinged, the aftermath, the people of the state of Indiana versus Richard M. Allen. And we are here because we wanted to discuss a couple of motions that got filed last week. There was a motion to strike that was filed, and then that was followed up by another motion to that was kind of a mind blower that was for preservation of evidence, which, you know, it was a lot to digest. I don't even know that Allie's been able to read it because we were down in Florida for the funeral. And the way that we're going to do this, I've got Andy backstage. He's got to be up early, like ungodly early to be in a dentist chair. Like, I can't even imagine being in a dentist chair at 7:15 in the morning. So he's been kind enough to give us his time this late because I had to go pick Allie up. So what we're going to do is we're going to bring Andy on. We're going to talk with him. We'll discuss kind of the context of the motions. We'll discuss Rei Davis and what's going on with him. And then I'm going to cut Andy loose so he can go home, crawl into bed, and get a good night's sleep. And then we'll go through the documents with y'all. I think it'll be helpful in terms of giving you guys context as well. So without further ado, I'm going to bring my friend, colleague, and just an all-around great guy, Andrew Baldwin, to the stage. What is up, my friend?
Hey, Bob.
How are you?
I promise this will not be a 4-hour cathartic marathon.
Dude, you've already gotten the crowd depressed. That's exactly what they were hoping for. You don't understand how much they love that. I can tell you.
I just got back and I was like, oh man, you and Andy, I'm not signed up for 4 more hours.
Yeah, me neither. I appreciate you. I mean, I reached out. I just want everybody to know I reached out to you because there had been somebody had alerted me that there was a rumor about Rei Davis in the DOC, and they were kind of dogging on the DOC, and I understand why they might think that. And but when people do things the right way and things are being done the right way, I want to dispel when they are when people are thinking they're doing something wrong. So that was the main reason why I had reached out, and I appreciate you letting me come on.
Hey, look, man, I've told you this before. I'd like to have you on every night. So just so you understand that, I always have space for you. You know, there's so much to talk about. I know that you're somewhat hamstrung in terms of what you can talk about, but you know, it's look, I mean, the state's been doing kind of their bizarro world tour that I've never seen before in a case like this, where it seems like it's a lot of apologizing about themselves and a lot of finger pointing and blaming of you guys and of us being creators, and that it's everybody else's fault that such a large portion of society that is following this case thinks that they have the wrong guy in prison. You know, so I'm happy that you're here because, you know, like I hate seeing that kind of stuff go unchecked. To be honest with you, I hate seeing them continue to push their narrative without it being
Challenge.
countered by
Scrutinized.
like when you file something like this, it warms the cockles of my heart, and I mean, it infuriates me on one hand, but it also, it empowers me. It makes me, it reinvigorates me for the fight, because that's what this is. Like this, now we're in the post-conviction phase of this thing, but we still have some lingering stuff, don't we?
Yeah.
So let's talk about it. Let's start flat out. So Rei Davis, and if you guys don't know, like I said, we're going to go through the pleading after the fact, but Rei Davis is an inmate at Newcastle Correctional, and he had some things to say very, very recently, and he's been trying to say it for a couple of years. But like the first thing I want to address, because I saw it before you called me, somebody had posted that they were concerned that Rei Davis had been moved to suicide watch. And so like, I was already worried that narrative was going to take hold. So I was relieved when you hit me up, you're like, hey, like Rei's fine. So why don't you tell us about what's really going on with Rei Davis?
Okay. Well, just in terms of, I didn't bring water up here, so I might get a little dry throated, but in terms of his current status, it is true that he is in some type of SEG unit. But the thing is, when I met with Rei last Wednesday, February 12th, one of the last things that he said to me was, hey, before you file anything or it gets out there in media, will you try to get me moved out of the pod that I'm in, because I'm in the same pod as Keegan Klein. And it just could be, for obvious reasons, it could be a problem. And so I have had somebody that I've dealt with in the DOC over the course of Rick's case that has been just an amazingly super help. Every time that I needed anything, anytime I had questions, anytime I wanted to go see Rick on a Sunday on the spur of the moment, I could text her and she would make that happen. So I reached out to her and she made it happen. And so we filed that, I think, about the motion to preserve evidence, which revealed that Rei was, talking about his conversations with Keegan Klein. That was filed about 4 p.m. on Friday. And about a half hour before it was filed, Rei actually called. I was on the phone or something, and he called just to let us know that he had been moved, but he had some questions about that. And so I got to talk to Rei today, this very morning. They were, again, Newcastle, kind enough to let me talk to him. He's not my client, and everybody needs to understand that, and he understands that for sure. I've made that very clear, but that doesn't mean that I can't assist in trying to keep this witness safe. And that's exactly what he asked me to do, and I wanted to honor that. And he is in SEG, and it kind of sucks for him because, he's going to be, I think his outdate's 2039. He's in for dealing meth. And, just get real about that. The people that are going to be the naysayers of Rei Davis, that's what he's in for. So, and he's going to be in there. He got what would seem to me a very ridiculous sentence, but that's beside the point, of 50 years. So he's got to serve half of that. And so his outdate is like 2039. And, he had developed, I guess, a routine in the dorm where he was at, if you want to call it a dorm. And the dorms I just learned a lot from him today when I talked to him. They have their individual pods. And when you're in a pod with somebody else, that doesn't mean that you're going to, when you go on rec, you get to go out with some people during rec and the others stay in their rooms, but you have access to each other in the pod. So if there's, let's say, 12 people in a pod, they might take out 4 of them for 2 hours of rec, and those 4 can kind of roam around and they can go in and see their buddies in the cell, in this cell, but they won't be able to leave the cell, their buddies. And so they talk and communicate through the cell, which is important, will be an important part of what I'm going to be talking about. But Reese, when I talked to him this morning, he said, it kind of stinks because my routine, he said, I really like him a lot because he's just said, I'm not mad. You did exactly what I asked you to do, and I appreciate that. And I'm not mad at Newcastle either. They've been very nice to me, and they're letting me talk to you and all that. But, I am on some restrictions that I wasn't on before because of where they placed me. And so I'm hoping that I can go back to the dorm, but to a different pod. And I said, why do you want to be in a different pod? Just so I'm clear. And this was super interesting to me. And it really says a lot about him. And I'm just way too transparent to lie about anything. I'm not interested in fabricating truth or anything like that. I'm just telling you what he said. Reese told me that the main reason, he said, yeah, of course I've got some safety concerns. Keegan is a big boy. And, when it's out there that I'm revealing conversations that I had with him, that could put me in some danger. But the bigger reason, he said, is I'm hoping that there's going to be an investigation, and I want there to be, and he used this word, integrity. I want there to be some integrity to the investigation. What he's hoping is going to happen is they're going to come, whoever it might be, law enforcement, state police, might come to the prison and interview different people, including Keegan Klein. And Reese's concerned that if he were in the same pod, remained in the same pod, that Keegan's going to march up and talk to him. And then who knows what Keegan's going to say about that conversation to save his rear end. And so Reese was very clear. I want there to be an integrity to this investigation, if an investigation ever even comes of it, which is what he's been asking for quite a while. So he's fine, but he wants to move back to his dorm area, but in a different pod.
Got it. So, and I know most of this is in your motion, but since we're doing this in the reverse, can you tell us what new information you learned from Reese and how strongly you feel about the veracity of what he has told you?
Sure. I think part of that requires me to go back in time a little bit to last March 27th. And that's when I went and saw Reese. We had received, I'm trying not, I want to try not to be adversarial as much as I'm able to not be adversarial. But, the dump of evidence that we received, in a normal situation, when there's something as important as one of the key players confessing, I'm in Johnson County, Indiana, Franklin, Indianapolis, Marion County, big city. Prosecutors, they will reach out to you and say, hey, I wanted you to know that this person recanted their story, or this person, there's a witness here that you need to know about that is telling a different story. And they don't try to hide it in the middle of 1,000 other, 10,000, a million other pieces of evidence. We never got that luxury. I mean, there was a night in March of last year when I was here, just like I am now at this office, going through the hard drives, and I saw this thing kind of buried, in one of the hard drives that talked about Rei Davis talking to Ron Logan, and Ron Logan confessing to him. So I went and saw Rei Davis on March 27th of 2024, and it was a very, Rei was a little standoffish. He didn't know, who I was exactly, or whether he could trust me, which is understandable. And he kept saying, just watch the video, just watch the video. And I said, well, I don't have a video. And he said, well, Mr. Baldwin, when they came in, they've only come in and seen me one time. Law enforcement came in one time, and they put a camera down right on a table, and it pointed right at me. And they said, we are tape recording you right now, or videotaping you right now. And that's what they did. And I said, are you sure of that? And he said, I'm 100%. How would I not know that? It's the camera was on, and they told me I'm being recorded. And he seemed very sincere. And so the next day, on the 28th of March, I emailed McCleland, and for some reason, Stacy Diener was on that. I think at that point in time, I thought she was going to try to help sort out the discovery issues felt that were occurring. And I just said, hey, this guy's 100% sure that he was videotaped. And he kept telling me that's what he wanted me to watch versus tell me what Ron Logan said. He did say Ron Logan confessed but watch the video. And I sent out that email to Nick and Stacy on March 28th, like at 10:48 p.m. And I never received a response back. And then, you get back into the case, and that's just one of those things that falls through the cracks, unfortunately. And I should have filed a motion to compel, or just to figure out what's going on there. But again, in a normal world, the prosecutor reaches out and says, hey man, there never was a video, or we're going to check on that or something. And you don't have to worry about,
we've taped over it, we've lost it.
well, yeah, that, well, I'll get into that later, but why I'm concerned. So then fast forward to last Wednesday, I had not talked to Rei, not communicated with Rei, but I started hearing murmurings about Rei after we filed the motion to correct errors. And so that caused me to, talk to the prison there at Newcastle, and they allowed me to go talk to Rei. And I went in and I sat down and I waited for him, and he walked in, and the first thing he said was he apologized. He said, I've got to apologize to you because I know that I didn't tell you a whole lot. I'm paraphrasing, of course, but I know I didn't tell you a whole lot, but the video should have shown you what I said to them back in 2017, what I said to law enforcement. And I said that I never was given the recording. And he was like, what? What? Are you sure? And I said, yeah, I'm sure. And then he said, well, the letters, I think he pretty much went right from that to the letters. Well, what about the letters that I sent Nick? Did you read those? And I said, I have no idea what you're talking about, man. I did not see any letters. So then Rei proceeded to tell me that in March, he thinks it was March of 2024. I'm sorry, March of 2024. Sometimes I view like, I think God is in the mix, okay? Because what's really strange is that Ron Logan is in Rei Davis's pod in 2017, and then Keegan Klein is in his pod in 2024. So Rei Davis is in this unique position where, if you believe him, he talked to both of those guys about the Delphi murders. And what Rei told me when we met last week was, when I met with you, and this is why he apologized, first of all, I didn't know if Rick Allen was involved. So I wasn't going to sit there and spoon feed you information to help you out, because what Ron Logan told me is that there were 3 people involved. And I didn't know if Rick Allen was one of the 3. So that's why I just said, watch the video and that'll tell you everything. The other reason I'm apologizing is that, or he said, there's things that I didn't know then though. So he didn't need to apologize for that, but he said, I got to know Keegan Klein over the next few months in 2024. And over that time, essentially Keegan Klein, and some of this I learned today when I talked to him, so I'm not going to, I won't do this chronologically necessarily, but what he said that when Keegan Klein was out on rec in their pod, he would walk up to the second floor where Rei Davis's cell was, and they would talk through the door. And the thing that was of interest to Rei early on was that Keegan was very interested in, Keegan had learned, according to Rei, that Rei Davis had conversations with Ron Logan back in 2017. And Keegan was very interested in knowing about those conversations. And Keegan was interested in knowing, first and foremost, did Ron Logan ever mention my name? And that was asked a number of times. Did Keegan Klein, or did Ron Logan ever mention my name? Keegan Klein was asking Rei Davis. And Rei told me that he fairly quickly understood, or thought maybe Keegan Klein was one of the other 2 participants that Ron Logan was talking about. So he nurtured a relationship. Rei Davis nurtured a relationship with Keegan Klein in an attempt to get him to talk. And talk he did, according to Keegan Klein. He gave a lot of specific details about what Keegan Klein claimed happened. And I'm not going to reveal all of those. But some of those I did reveal in the motion yeah, go ahead.
I was just going to say, I didn't read the, yeah, you're good, Dad. Sorry.
Hi, Dad.
Wow.
I didn't read the motion, but it sounds like Keegan Klein made some admissions to Rei Davis as well.
Yeah, according to Rei Davis, Keegan Klein gave somewhat a blow-by-blow of what happened on February the 13th and going into the 14th. A lot of it, he said, corroborated or matched what Ron Logan had told him. There's some new information that, again, I'm not willing to share, but is very, very interesting. And then Matt Hoffman, who's one of our investigators, and Jennifer Auger and I over the weekend took that information and looked at crime scene photos and other stuff to try to determine whether there was some validity. And our, non-expert naked eyes were like, and brains were, yeah, there's some stuff here that matches up. And so we're most interested in, taking what Rei told us and matching that up. But what we'd also be interested in is getting these letters that Rei Davis says he sent Nick McCleland, because, I was at the facility on last Wednesday for like 3 hours before they kicked me out, and they were nice about it. But Rei, told me a lot, and he said, I wrote Nick McCleland. He thinks 8 letters, 7 letters. He thinks between August of 2024 and right before the trial, and then 1 after the trial, for a total of 8. That's what he thinks. And he said, in those letters, I really got specific because, it was all while kind of in real time when Keegan Klein was talking to me. And so, and part of the story that he told me that I shared in the motion was that Keegan Klein and Rei Davis knew each other because they shared child pornography on burner phones. And that's how that was how they knew each other. Roughly about every 3 months to 6 months, Keegan would meet up with Ron because Ron wasn't great with technology and the burner phones, and he'd have to help program whatever they were doing with this.
This is freaking, it's just insane.
Yeah.
It's completely insane. It's like all of the avenues that they had right in front of them, like, are all converging, and they just ignored all of this and shoved it under the rug. And now there's
one other thing that Rei told me was that he had volunteered. He said, if you watch the video, you'll see that I volunteered to wear a wire when Ron Logan, because they didn't seem like they believed me. And I said, well, put a wire on me and you'll see that I'm not lying. I'm telling the truth. And he said they weren't interested. Now, listen, everybody, Rei Davis, I don't know him. He might be lying about everything. Okay. But
they still need to disclose everything they have.
Well, he could theoretically even be lying about the letters that he claims that he sent Nick. But when I talked to him today, when I talked to Rei Davis today, I said, man, you are putting your neck out there for truth and justice. And I appreciate that. I also am putting my neck out there to a degree because, if you're lying to me, I'm going to look, very foolish. But I have no choices. I have to do this to preserve the record. I've done my due diligence, and I believe what he's telling me is true. It might end up not being true, but he just said, Andy, why would I do that? I'm going to be a target now. I mean, I just wouldn't lie about that. Just be dumb. He said, by the way, there's cameras everywhere. So when there's going to be cameras showing me Keegan Klein coming up to my room all the time, there's going to be cameras where I show me giving the letters or shoving them under the way they hand out letters there, or when they mail letters, they do them. I got into all this minutia with him because it's important. It makes me feel better about, I already believe him, but I wanted to verify that there wasn't any anything hinky going on here. And he said, it's not that complicated. When you have an envelope, you write your letter, you put your stamp on it, you have stamps in your room, you slide it under your jail cell, and then a DOC employee comes around and picks up the mail, and then they take it somewhere. And he said, I'm thinking that they probably also at Newcastle and every other DOC facility memorialize the incoming and the outgoing mail, either by scanning it in,
right,
or at least memorializing it. And he's like, I have no problem with that. I mean, I hope they did. And he said, I hope that they photographed he said, I didn't send it by legal mail. He said, if it's sent by legal mail to a prosecutor's office, they may not look at it. But if I just sent it regular like I did, I'm hoping that they opened it up and took images of it, because if they're missing, if Nick says he never got them or whatever, then at least they would be here in Newcastle. And so, I mean, the guy, everything about him screamed that he's telling the truth.
Yeah, and like a couple of follow-ups. So as far as Klein goes, in the hearings in late July, early August, the 3-dayers, at that point in time, you guys went pretty deep, and I think Jennifer handled the Klein thing, which surprised me. I was surprised that you guys kind of went that deep into it. And I, at some point during this conversation, I want you to try to explain to people why we as attorneys, people are gonna be like, oh, I thought, it was the Odinist, Andy. What about the Odinist? Now it's Ron. It's like,
yeah.
But I want to get to that. But as far as like the Keegan Klein thing, we've got this, it's a different story, right? I mean, what he originally said was the thing with the red, him in the red truck with his father. They drove down the access road. His dad got out of the car, came back an hour later. He's bloody. And we all know that story. That's the story which led to the search of the Wabash River for the knife and the phone, so like, as far as Klein, like he's a different guy in terms of whether or not we think that we should believe him. I mean,
right.
To go back to what you were talking about with Rei Davis, I happened to pull up his appellate decision when he appealed his case, and I was reading through the fact pattern, and that 50 years is obscene. They treated him as if he did have a meth kitchen when he was cooking. He wasn't. He was the one who actually called the police on himself. He said, I've got a warrant out. I got a bunch of, like, the guy was trying to stop himself from being a meth addict was really what was going on with them. They end up coming to the house. They don't find anything that was even close to what you'd need for a meth kitchen. They found precursor stuff, the ingredients to make the meth, but none of the things that you need to cook it. So, but they still charge him with distribution, and they hammer him with 50 years. But, being an addict, and the fact that kind of the way that it went down, I was struck by the fact that the guy doesn't appear to me to be a liar. There's crimes of dishonesty that exist in this world. And that's not to say that addicts at their worst will lie, cheat, and steal to get that next fix. That's a reality of the situation. But that doesn't mean that somebody is fundamentally a liar. And I don't get the sense, because you and I talked about this before today, when we talked the other day, and I'm like, look, man, I mean, like that is a long con. With no end game for him. Like, he's not looking for time shaved off. He's not looking for that, and like that old axiom, snitches get stitches, exists for a reason.
Yeah.
He's put himself in harm's way, whether it be by the hands of Keegan Klein or another inmate that's taken exception to the fact that he's in there ratting on people. I mean, the fact of the matter is he's put himself in harm's way, which gives what he says a lot of weight.
Yeah.
And the other thing, like, as far as like prisons, typically when an inmate has a letter that they're sending out, if it's not legal mail, typically the prison will say, all right, don't seal it, because we're going to need to look through it. They're going to look through for contraband. They're going to look to see what was written, see if the guy's making any kind of confessions, anything that could be usable in court against that person down the road, or if they've got an appeal pending, depending on if you're in prison or jail, but they're always looking for contraband. That's like just an existing thing. So it would seem to me that there's going to be a paper trail. which would make your life so much easier.
Yeah.
Right. I mean, like just to be able to lock it in from the facility itself would be perfect world type situation. If it's not, and we're left to Nick McCleland, okay.
Mhm.
What was your conversation with McCleland in terms of these letters?
So before I know I'm going to forget this, so I want to talk about that. But one of the things that also happens with Rei Davis, all those things that you just said are accurate, that snitches get stitches and all that. And what's he getting out of it? Number one, Rei never, a lot of times when you're dealing with people in this situation, I've done this for 30 years, you know, hey, I got some information for you. Hey, can you do my modification, or can you take my case on, and that kind of thing. He doesn't want any of that. In fact, in the documentation that I read from 2017, in what he told the police, I don't want anything but justice. That's what he said back in 2017. That's what he continued to say even now. He is bothered that Nick's calling him a liar and that he failed a polygraph. And he's like, I don't know how I failed a polygraph. Does medication have anything to do with it? Because I have Tourette's syndrome, a mild form of that, and I'm on medication for that. And I said, yeah, that can affect polygraphs, but polygraphs are crap to begin with, in my opinion, and should not be trusted. There's a reason they aren't allowed in court. And so don't be bothered by that, Rei. He didn't like being called a liar. Okay. Now, as far as Nick McCleland is concerned, when I got back on the 12th, last Wednesday, I drove past my house where I was really super tired and I just wanted to go home, but I knew I needed to get back here and do some work. And I got back to my office and I reached out to Nick, and I sent an email to Nick and Steve Mullen. Have not communicated with them for quite some time, ever since they've been, calling us unethical and all the things that they've been saying and doing, which I haven't watched. People will send me some clips and so forth. It just seems very bizarre what they're doing. And I don't understand it, but especially with their track record. And again, I really don't want to, I'm not here to be partisan. It's going to be, or whatever you might say, but it's going to probably have, some of that's going to have to be talked about. But I sent an email to Nick, or I don't know, maybe around 8:00 that night, last Wednesday. And I just said, hey, it's my understanding that you got 8 letters, roughly around 8 letters. I don't also want to get into the game, by the way, where it's like, well, he said 8 and there's only 6, or there's whatever. I mean, Rei's doing the best he can to remember, but he said, I think it was 7 before, between August and the trial, and 1 after. And then the one after, he's basically says, Nick, you're a bad person. You let an innocent man be found guilty. And so I emailed Nick and I said, it's my understanding there's 8 letters. I'd like those letters, please, by the end of the day tomorrow. And Nick, around 3:00 the next day, the 13th, which was a Thursday, about 3:00, he says, you have what we gave you. And I'm paraphrasing, but roughly, you had your chance with Rei Davis. You strategically decided not to call him, and you lost. Your guy was convicted, and file whatever you're going to file. And I, whatever, that's fine. I responded back, that's fine. I just want to know the answer to this question. Did you get 8 letters from Rei Davis? And if so, are you saying that you sent them to us? And and those were the 2 questions. And I've not heard back from him since then. And kind of my own independent analysis is, if you didn't get the letters, then you say, I didn't get the letters. And if you did get the letters, you say, I did get the letters. And if you did get the letters and you sent them, then you say, I got the letters and I sent them, and here's the dates that I sent them, and here's how we sent. My paralegal, Sarah, and I went through every piece of evidence that came in between March, that we believe came in between March and the present. And most of that, except for one dump in April, most of that came in the form of e-discovery And on a couple of times we might get attachments to an email. So we went through all the emails. We went through all the e-discovery. We clicked and clicked and clicked all the way through all the sub files and the files. And there was no letters from Rei Davis. And it doesn't mean that they didn't send it. I mean, it's possible. But again, my due diligence has been done. I have looked everywhere for that stuff over the last 2 days, since Friday and Monday, and over the weekend even a little bit. So
it shouldn't be a game that you're supposed to have to figure out. Like you said, in a normal world, if they sent them, they would have responded, yes, and here's the dates that I sent them. But in this world, you have to think, could this guy be not answering just to set me up to look like a fool when I go full force to demand them? And that's like, that is not normal lawyering. That is not the kind of shit we're supposed to be worrying about, with all the actual things that we as lawyers are supposed to worry about, handle, navigate. A sneaky, shady, possibly setting you up to, to look like you blew something up that was nothing. It's disgusting.
Well, he's gonna,
that would be the only reason not to say in response to that email, I sent it on this date, and I got 8. That would be the only
there's another reason, and that's because he doesn't know what to do. He's
right. Well, but that's the situation if he didn't get him, or if he did get him and didn't see him.
Right.
So if he got him and he's trying to hoodwink you and has you out here, kind of flailing in the wind, and now we're out here talking about it, and then he's going to say, oh, well, here's my proof. Here's my email I sent on April 15th, tax day of, the Rei Davis letters I sent you, and to Allison's point, that's just bullshit. Because if he had that then, or if he has it now, he had it then, and he's just searching for it. He's typing in, Rei Davis, and he's searching for when they sent it. So, it's like that kind of, and it's beyond gamesmanship. I'm used to gamesmanship. It's to me, it's borderline unethical. It's not how this is supposed to be done. There's supposed to be a modicum of just
professionalism
at all times. Like professional, all of those things. And what we've got here is a situation where it's scary for you. With everything historically that's gone on in this case, you once again sitting at the computer, this motion's prepared, and you're hitting the send button when you're e-filing it, man, and it's like you're shitting your pants. You're like, man, well, I mean, like, we looked, right? Like, I can imagine you in your office. We double checked everything. We looked, right? This shit is not here, because once I send this out, it's out there for the world. And I know you, man, you're a stand-up guy, and you'll take the beating if it turns out that they're out there. But in terms of you doing your due diligence, and we're talking about what, 3 million pieces of documents, between videos, audio, documents. I mean, it's a ton of evidence that, the reality, Andy, is that when you guys got back on the case and you guys got the evidence dumped back on you, you had to go back through it again. It didn't come back in the form that you sent it back to them,
correct,
when you guys were removed. So you're having to reinvent the wheel, and you just didn't have a ton of time, man, because the reality is that you guys had to prep for trial, and you're left there hanging in the wind where Andy Baldwin's sitting there focusing on his third-party culprit aspect and that strategy, still not knowing, because that judge would not have hearings that were timely in order to give you an idea of what you were going to be going to trial with a few months down the road. Instead,
sending out jury
until the end of July and the beginning of August, and then she shuts it down.
Despite jury questionnaires going out asking about Odinism. I'm sorry, babe. I just want to know, technically, Nanook, under Indiana law, are they supposed to specifically label or identify in some way Brady material and say this is Brady material? And not
that is a good
in a million pieces of paper.
There's some trial rules that talk about, labeling things so that it's not vexatious on the defense. I don't know. That's something that I don't know the rules on. But Allie, that's a good question as it relates to Brady material. Now, Brady material, I suppose, is in the eye of the beholder. If they don't believe, Rei Davis or Keegan Klein or Ron Logan, they might conclude that's not, in their mind, that's not Brady material. I don't know. But I don't know if there's a specific rule that says that. I just know that in doing this for so long, and I know this is hard for Jerry Holman and Doug Carter and McCleland to believe, but across the state of Indiana, I get along terrifically well with prosecutors, and they would almost all of them, with some exception, they would almost all of them would call and say, "Hey, man, I got this thing, and you need to see it." And then we might laugh about it because it's like, "Wow, we thought this case was going this direction, but now." Hey, and then I'll say to them, "Hey, man, thank you for being honest." And they're like, "This is what we're supposed to do, right?" But that's it's not really happening here so much.
How long does McCleland have to answer? How long does he have to respond?
Oh, I think 30 days or until the judge rules on the motion to correct errors. If she denies it tomorrow morning and denies everything else by tomorrow morning, then he's just not going to have to, I'm guessing he just doesn't have to respond to anything.
And what do you think is going to happen if you had to guess based on the history of this case? What do you think is the most likely scenario, Andy?
Well, I'm sure she's going to give us a retrial immediately, probably next week.
Let me ask you, how I would literally die of a heart attack in my, as soon as the clerk sent that to me and I read it, I'd fall over in my chair. Allison would have to call an ambulance. It would be a nightmare. I'd be so stunned. Yeah. Look, in terms of, let's kind of talk a little bit about this thing that we have to do as defense attorneys when we have no obligation. We have no burden in a case. We like if we have the ability to put forth a third party culprit defense. We love that because it's great at trial to be able to say, okay, look, there actually is somebody else that you can point the finger at, and it's this person right here. Mm-hmm. And this is why. It's we love that. It's favorable to having to rely on reasonable doubt. That's always our fallback, which is unfortunately what you guys were left with after you were stripped of every single possible defense that you could put forth. You had to rely on reasonable doubt. But explain to the people why there's nothing untoward about pivoting or throwing Odinism in there. But let's look at Ron Logan too. In terms of why we do that. Why do we do that, Andy?
Well, I want to say that Delphi is a little bit different in my eyes in this regard. I feel like we are almost being forced to prove what happened. That's not the way that the law is supposed to be, of course. And I, nor you, nor Allie, nobody knows what happened. And when you're defending somebody, certainly there are trials and cases where you're like, I think this is kind of a bunch of crap, but this is all that I have. And, and sometimes that you walk out of a trial and this, guys, you walk out and you're like, holy crap, my client, I thought it was a bunch of crap, but it wasn't. I mean, the people got up and said what they said they were going to say. So you just never know because life is crazy.
Right.
But in this case, I stand by the Odinism. By the way, these aren't mutually exclusive possibilities. There's a third person, and I don't know who that third person is. If that is true, Keegan Klein could be lying, and then the Odinism thing's back in full force on its own. The Odinism, it might be the sticks might be these guys they knew that Abby was dating one of the third party suspects, and the father was an Odinist, and they are trying to set him up. I mean, we don't
know that there are Odinists in the area, and it's a red herring, because it sounds like it's something that people that know that subculture are aware exists kind of widely. It seems.
Okay,
Yeah,
the tattoo parlor in Delphi, Indiana was called Odin's Den. Like
yes,
this concept that Odinism isn't a thing in Indiana is absurd.
yeah.
Like anybody who says that has zero credibility in my eyes, because it's just like we can see it with our own eyes. I mean, when the thing broke with the Franks and we're looking, and the first thing obviously I did is I'm on Brad Holder's Facebook page immediately. So like while I'm reading it, I'm like on this guy's like everything is Pinterest, like anything that I can find that he has social media wise, and I can see immediately, having no knowledge of what Odinism is, that this guy loves Vikings. You know, he is a big Viking guy, like whatever that means. And in the context of a deeper meaning, you start to, as you dig in, you start to get an understanding of what it means, that it's something that they take very seriously, that they have incorporated into their lives as a way of living. And like there is no denying that is something that is alive and well in the state of Indiana and other places, but Indiana in particular. I mean, it is a thing. I'm sorry that we keep covering your face with this. Is there any way we can move the three of us in a row so that poor Andy's handsome face isn't covered by these
please
giant...
cover my face.
I don't mind. Stick me at the bottom.
Please help your viewers out by covering my face.
Hey,
there
you go. They took you all the way off.
You know, Bob, it's funny. One of the things that happened early on in the case when I found out about Odinism is I'm in Elkhart chasing down a lead. It was one of the crazier leads that I've ever had on the case, where I went into this seedy motel room in Elkhart, and these people are talking about cannibalism and stuff like that. I mean, it was just nuts. And it was early on. So I was like, oh, is this what I'm going to be in for? But on the way out, I get behind a car. Matt Hoffman I think was with me. And on the license plate, the vanity plate said Odin something or other. Odinist, and then there was a bumper sticker with it like Odinist on board or something like that. I don't remember exactly. I photographed it and sent it to Brad Rosie, who was still struggling at that time with the possibility of Odinism. And you know, as you said, Bob, it's around. It's a real thing. And for those who say again, you know, well, Andy, is it Odinism, or is it is it Ron Logan, or is it Keegan Klein? Ha ha ha! It's like, what you tell me? I mean, were you there?
Why don't the police investigate all the possible scenarios and let us actually know?
We are not doing our job if we don't go down every rabbit hole. I don't know whether these guys, you know, this is the difference. That's the difference between me and maybe the state and the way that they view things. They viewed it like this is what happened, and we're going to have to say this is what happened. And I say, gosh, if what Keegan Klein if Rei Davis is telling me the truth and Keegan Klein is telling Rei Davis the truth, the state has some major problems here, and they needed to send those items to me. If those things are in the existence or sitting, you know, my belief of probably what's going on right now. And I could be wrong. And here's another difference. I will apologize. I will stand up and say I'm wrong, and I apologize for that. I still haven't heard Steve Mullen apologize about taping over things. There's no shame in him at all. And by the way, while I'm on that topic, can I say something about how long it took them to let me know that? I don't think that was kind of not talked about so much. It's bad enough that stuff was erased. We're talking about important interviews right within, well, they say that it was erased, okay? Because I'm not taking anything at what they said at face value necessarily, you know. But I had been asking for these interviews for months and months and months and months, and I did not learn about these erased videos until February of 2024, when I had been asking for them for months. And the way that I found out about them wasn't Nick calling me up and saying, hey, man, I know you've been looking for this stuff. We finally figured out what happened. These important interviews, the first few weeks, they were all erased, man. And we just found that out. No, what happened was it was stuck in, like, they sent us a bunch of discovery, and then you had to read the fine print. And in the fine print, it said, By the way, the interviews from February 14th through February 28th or whatever it was, they were all erased accidentally. That's how I found out about it. Nobody called me. And again, let me talk about what happens in the real world with prosecutors and even law enforcement who are on the up and up. What they do is they call you. When I'm asking for these tapes, you know, for months and months and months, they would have checked out what was going on, and then they would have personally called me and said, we figured it out. But it wasn't even that. It wasn't that. And it wasn't even a letter saying, hey, we figured it out. It was, I had to figure it out on my own. And then on top of that, guys, remember, I then asked, well, is there a document, a report that says what happened?
Right.
This? And then we get an undated report from Steve Mullen that he claims happened in August of 2024 that puts a bunch of gobbledygook explanation as to how these things were erased. That's just not normal.
No, it's
not normal.
It's not normal. It's insane. I mean, anytime, like as soon as it kind of made a transition from, you know, where they'd send us a video and we'd get the old CD-ROMs, and then and then it turned into DVDs, and then it went to flash drives. Like anytime the state was aware that they sent us something that wasn't working, if they were ahead of the game, they'd let us know, and we'd get it in the mail saying, hey, what we sent you before didn't have what we said was on there, and this is what was supposed to be on there. Like this whole game that they're playing, and to lose the video from the most critical part of the investigation is so mind-blowing to me. And I'll never forget your cross-examination of Mullen when he's laughing. You're like, is there something funny? Is my client sitting here with his life on the line? Is there something funny about the fact that you lost days and days and days of interviews during the most critical part of the investigation? Is there anything funny about it? Man, dude, it was like that whole thing was unbelievable to me. I mean, and it's just like, that's the thing about this case. That's what you're talking about. This case is different. Yeah. It's like, I recognized it immediately that there was something off about this case, that it just wasn't being tried on the up and up. Yeah. And that was from an outsider's perspective. Yeah, I wasn't calling you, Andy, and saying, hey man, this, you know, it's like this is me reading the pleadings and as an attorney understanding that something is horribly wrong here.
Yeah. And something stinks in Delphi.
Something stinks in Delphi.
We'll talk about, and again, I mean, I'm trying to educate people. I guess you probably have done this or do a good job of it. I don't, again, man, I know, I'm sorry to tell you this. I haven't really, I was on your show.
Why do you have to rub it in?
I don't watch these things. Andy. I don't watch any shows. If I were going to watch a show, it would be your show.
Oh, there you go. There you go.
You know, the what happened with when Todd Click hires a lawyer and sends that because he doesn't know what to do, because he thinks they may have the wrong guy. And so he takes the time to hire a lawyer. The lawyer takes the time to write a letter and send a flash drive with a letter saying, I think you may have the wrong guy. Did you ever look at our evidence? And that's exculpatory. I mean, it is. And they can try to argue that it isn't, but it is exculpatory. And by the way, it also contained, the flash drive contained interviews that I had been asking for in August and September. And so Nick gets that in May, and then June, he got it May 1, June 1, he doesn't tell us, July 1, he doesn't tell us, August 1, we're getting ready for depositions where those things could have been very valuable and useful in preparation for the depositions of Holman and the other law enforcement officers that we deposed. And he didn't give it then. He didn't give it September 1. But by then, at the August 10th Jerry Holman deposition, Todd Click's name got mentioned in one of the documents that I presented to Holman. So now they know we know about Click. And now they know that they had known that I had driven down to Georgia to find out the mimicked crime scene photo. They knew we're doggedly pursuing the evidence. And Nick McCleland had to know that this really burns me up, man. I told you I was not going to get upset, but, you know, Nick McCleland knew that, that we were going to locate that. And so and he had that since May. September 8th, I believe was the day we get a dump, evidence dump. It was in the form of flash drives primarily. There might have been there was also some hard drives, but we get a flash drive with the Click stuff. Here's what did not happen. Andy, Brad, I'm really sorry. May 1st, I got this mail, this certified mailing from a lawyer in Rushville, and it just sat on my desk, and I just left it there, and I didn't even look at it. I'm so sorry. You should have had this way sooner. My apologies. I'm not trying to hide anything, guys. I'm not. And I don't want you to think that way of me. And I would have been, oh, okay, yeah, that happens. But no, instead he or Mullen put it in a disk, a flash drive, and that's how I found out about the Click stuff.
And buries it.
And he, I'd say buried it, instead of doing the honorable thing and calling. And you know what? Where is the common decency there? Where's an apology? Is the journalism, by the way? Where are they have been? Holman was on, McCleland was on different podcasts from what I've understood. Has one person asked them about those things that I talked about and proved in the Frank's memo where I gave them the goods? I mean, I had footnotes and I showed everything. Has anybody said, why did it take you so? It's not that complicated. Here, let's see how long it takes me to form a question. Nick, how long did it take you to give the Click stuff, turn it over to the defense, and why did it take that long?
Right. And
it's
look,
not hard.
I've said it 5 times now. Nick McCleland, Jerry Holman, Doug Carter, any of the law enforcement has a standing invite to come on our show, and I will be more than civil. I will ask those questions because they require answers, but like no one's coming on here, which speaks volumes to me. That entire side, everybody that's been on that side, whether it's podcasters, whether it's whoever, no one is willing to engage in the conversation, which when people do that, Andy, it makes me suspicious immediately. I'll stand by my position always. Like I fear nothing. I fear no one. I will go on
no man.
Show. I will talk and I will defend my position. And if I lose my position, or if somebody proves me wrong, I'll eat crow and I'll say, hey, you know what? Thank you for enlightening me. I was not aware of that. That's what you do when you're trying to get to the truth in a matter. What you don't do is you hide. And everybody on that side of it has been going out doing this spin control tour post conviction, and it's just bizarre to me. And again, like I'd love to have Nick McCleland. I'd love to have Jerry Holman. Come on, tell me off. Tell me how I swayed everything to guys.
Tell us how we had it wrong. I ended up getting Rick convicted. That's all my hard work out here for these last 2 years got Rick convicted. That's how much I swayed public opinion. Come on, tell me. I'm here for it. You know what I'm saying? So,
and I don't mind tough questions at all. Russ McQuaid is a local journalist here. I got asked. I did several interviews. Again, I told you when I first got on your show, I wasn't planning on doing any of this until they Holman and others came out and started saying some outrageous things, and then I needed to fight back. But now, we are full bore. But Russ McQuaid is an example of a journalist that asked me some tough questions, and that's fine because I know that Russ would go out and ask the same tough questions if Nick McCleland would talk to him, but I don't think that he will. And I'm not going to go on podcasts, however, that are going to be unfair, but I don't know that these guys that I joked about the Prosecutor podcast show. I wouldn't mind going on that show if I thought they would be fair. I mean, just be fair and ask fair questions. Are you asking? And here's how I know you're fair. Are you asking tough questions of the other side? If you are, then that tells me that you're going to be fair to me as well. And because I can't control how much they talk over me or whatever, if they're going to cut me off before I get my point made. I just want fairness. That's all I've ever wanted. Ask me tough questions. I mean, the whole leak stuff is, the weaponization of that over time. It's sad and it's old news and it's terrible. And I still feel awful about it, but man, I mean, can we move on to something else?
Right.
I mean, there's a whole world out here of, missing evidence and potentially missing evidence on this Rei Davis business. Can we
does
talk
no
about
one care
that?
about the truth?
Yeah,
But
the truth.
but it's baffling because it's like the judge has been confronted with so many things. Like we say, even when I'm defending someone, I was like, that's just one coincidence too many. There's no selling. I don't believe he's innocent. A jury's not going to believe he's innocent. It's too many bizarre things, coincidences, whatever you want to call them. And that's been going on with this case from the, not chronologically and when we've learned about them, but from, missing videos of interviews and, evidence not getting sent. And it's just like, how many different things need to be put right in front of her face before she says, maybe, even just a maybe something's not on the up and up here. Like maybe something stinks. Like maybe I need to delve in a little bit. Maybe I need to pay a little bit more attention or give a little bit more credence to this argument. And it's like, to me, it's so many times and I just see nothing. Like
That ship has sailed for her. At this point, she's more than willing to have the appellate court overturn her. Like that, she's too dug in. Like there is no moving the needle for Judge Gull at this point. I mean, like just the volume of things that she's seen, and I mean, nothing affected her. I mean, to hear that the headphone auxiliary jack was activated and then unplugged, between 5:22 or 5:23 and 10:22, whatever the time frame was, just had no impact on her. I mean, to me,
well, also that they Googled their comeback for that was a Google search on a break, and that's how and she allowed that to come in. And I don't want to sit here and talk about Judge Gull. I mean, she,
no, we'll do that.
We don't see eye to eye on a lot of stuff, and that's fine. That's fine.
Yeah, you've like, oddly, for those of you out there that are not aware, Andy actually has a murder trial coming up with Judge Gull the next couple of months. So he's back in front of her, different case. And
I expect that she's going to be fair and do the right thing. I do. I just believe the best in people. I do. And that's why this has been a very difficult case for me, because, I give people breaks and then something else happens. Then I give them another break in my mind, like, okay, surely this is, and then I give them another break. And then, you give Steve Carter a break. Then he gets up and says some of the most crazy things. And, hey, he told me one time, I want to have a beer with you when this is all over,
yeah, sure.
Come on, get real, man. I mean, he's not, he's embarrassment. He's a shameful human being, really. And hey, Bob, I'm like you. Like when I'm at home with my wife and we get into disagreements or arguments. I mean, I've been married for 28 years, and here's the way that it goes down. She's a lawyer too, and we each present our facts. We make our arguments, and one of us usually is wrong, and almost always, if it's me, and if it's her, either way, we're going to say, you know what, you're right on that. And we give in. And if Doug Carter came in here right now and said, you're wrong about me, and we talked it through, I would still give him the benefit of the doubt, even to this day. But, it's less and less. And he's really going to have to like, if he called me up on the phone and said, I heard you were talking about me, why don't we go have that beer? I'll prove you wrong right now. Guess what? I'd go have a beer with him.
100%.
And I'd hear him out. And I'd want him to hear me out, because I don't think he knows. One thing that he said recently that was kind of weird was that, he was all involved in this case and making decisions. Well, that's not what Tony Liggett said. Tony Liggett said, and I believe it was Tony Liggett in his deposition, said he was basically the mouthpiece that, we gave information to, and then he would get up in these press conferences and talk, and that he didn't really have a whole lot. So, and the whole thing that he said about, why we got rid of the FBI, it was a nice thing, and it was there was not a federal nexus. That's not what Jerry Holman said. Jerry Holman said that they were that he said it gleefully. Jerry Holman said gleefully on August 10th, a Friday, 2023. Jerry Holman kicked them off the case because of problems that he felt the FBI had, and he told them to leave and all that. And Holman was very proud of Doug Carter kicking the FBI out. Yet Carter, this is the guy who professes to be honest and have integrity, well, somebody's lying there.
Right.
Doug, are you interested in who is Jerry Holman lying, or are you lying when you talked the other day or whatever, some clip that somebody sent me about you talking about why the FBI was kicked off? Okay. I mean, be honest about it. If they were kicked off because they screwed up, or you think that they screwed up, then be honest about that. Jerry Holman, if they weren't kicked off, then you shouldn't have said that under oath in a deposition. But there's two different competing stories here. And again, nobody cares. Nobody, they don't have any shame. They don't care.
Well, but there exists this other faction of cops that do care. And these are guys, when I'm talking about Todd Click, I'm talking about Kevin Murphy. And I've become friendly with Kevin Murphy. Kevin Murphy is an absolutely stellar human being, first and foremost. Forget his profession. Like the man is true blue as you can get. Like every ounce of that guy is honest. He's what you want every cop to be, like, truly. And like at some point down the road, Murph's going to come on this show. Now he's smart enough to know that what all of us are hoping is that this thing gets retried, and he's going to have to testify, so like he's going to sit back and he's going to wait until that day comes. And I obviously respect that. But this concept that every cop that worked this case was like the Holmans of the world just is not accurate. There were cops that cared about the truth. I know of a cop that was in the Carroll County Sheriff's Department, look, there were cops that cared deeply about this case, that didn't agree with how things were being done early on, that had devastating impacts on their career. And, there are just people out there on the law enforcement side that have stepped out against their own interest, and have been willing to say things that they are trying to speak truths because they care about the truth. I mean, like, ultimately, like, people just dismissing the Odinism thing like it was something that you cooked up in your back room while you were listening to your albums back there, and it wasn't based out of the discovery. I mean, I don't know how many times I said this over the period of 2 years. I'm like, Andy Baldwin did not create the Odinism defense. That was provided to the defense by the state, and it was cops, 3 just completely reliable, trustworthy, decorated officers that had been doing it for decades, that really believed that they had stronger suspects than the guy that had just been arrested. It's that simple. And I mean, how is an individual who doesn't have access to the discovery, how am I supposed to look at that as a citizen? I mean, I'm like, am I supposed to like just disregard it because you're a defense attorney? Oh, well, Andy's a defense attorney. They all come up with bullshit, It's like, no, that is not how this thing works. When you're coming up with that kind of defense, it merits discussion. It merits.
Well, you better be able to bring it if you're coming up with something like Odinism. You better be able to bring it. And
you have to.
There's 136 pages footnoted with exhibits that are referred to that brought it.
And that's the thing, you asked journalism, you asked, where is the journalism? And we've seen these motions being filed to intervene. And as you see from the comment here with Sleuthy Goosey, even, non-members of media, everyone's trying to get these exhibits. What do you think about that? And do you think it'll ever get addressed in the near future?
I don't know. I mean, I think I had heard that Andrea Burkhardt had tried another, another writ of mandamus, and that for whatever reason that was not accepted. I don't know if it was not properly done or whatever. That's way above my pay grade. That's Maggie Smith and Kara Weineke country, and those guys are just heroes for me in what they did back in the fall of 2023. And so you'd have to, they'd be a better people to ask. Is that ever going to be? My opinion is, and I've got a case in the Court of Appeals right now on a Access to Records Act. that I only know about it really because of Maggie Smith and Kara. It's just not something that we trial lawyers typically deal with. But I think, Allie, that the answer is, yeah, that stuff's going to come out at some point. It has to. It's not sealed. And the Access to Records Act require that it be made available to the public. So I'm hopeful. Listen, I want transparency. I wanted cameras in the courtroom. I want Richard Allen's statements from October 13th and October 26th out there for public consumption. I want all the stuff from the Franks memo, all the exhibits out there for the naysayers that say that I made up a bunch of crap. It's all there.
And I wonder if that was the journalist's way of trying to answer your call. Well, all right, let's get the documents.
That was Dateline. Dateline. I told you, Dateline filed that thing. It was NBC. Dateline's not doing any digging.
There's somebody else who just filed a motion in.
Yeah, I got news for you, Andy. The real media, the real investigative journalists are right here on YouTube, on Twitter, on social media. Like legacy media doesn't do it anymore, man. They all have agendas. They all, like, no one's asking the tough questions. Like, like the real diggers are right here. Like, this is where the people who are going to dig into this case. And you know what? Like, there are a lot of brilliant people out there. There just are. And there's a lot of people that care. There's a lot of people that care about the truth. And, and finding it, whatever that may be, Andy, whether it's Rick did it or Rick didn't do it, we need to get to the truth of the matter. And the only way that it can be done is by just transparency and sunlight, and everything has to be put out there. Like when they're hiding everything, when everything's done in the shadows, if it doesn't make you as an American feel slimy, and if it doesn't make you concerned, I don't know what to tell you. Then start reading our history. Like that. Just, we're talking about the government here. Like, since when did people start trusting the government? Like, honestly, I've never trusted the government.
Well, they're about to finally release all those documents to show that the CIA killed JFK and Martin Luther
there were
King.
two shooters, and MLK and all that stuff, and but.
So maybe in 50 years we'll get some.
I just hope so. I mean, it is what it is. It's maddening. And, I'm trying to get back into a normal routine in my law practice. And then the Rei Davis, then we file a motion to correct errors. And then Brad and Jennifer and I keep getting sucked in. Brad is a busy trial lawyer, and he had a jury trial last week. I'm happy to report he got a not guilty. He's a very good trial lawyer, and because of that, he's very busy. So I did want a buddy of mine named Dave Harper, who loves you, Allie, by the way. He didn't say much about Bob, but he didn't.
Wow.
Say, I'm sorry to tell you
Hi,
that.
Dave.
But
wow,
he actually likes that you smoke. He uses a
vapor,
and he's. I think that's part of the attraction. I don't know, but anyway.
Plus, she's a smoke show. Look, man, here. So look, this is the way. I want to get into the Brady before we let you go.
Yeah.
So look, it only can go one of three ways. Either Nick McCleland knew of the evidence and didn't disclose it to you, which is like obviously Brady, or Nick received them, wasn't aware that he received them because trial was looming.
And it's
got
newly
tossed
discovered.
in a box. Or, the third scenario is that they sent them, right? So like one of those three things has to exist.
Well, there could be a fourth scenario, and that is that Rei Davis lied and never sent those. But again,
but you did say, yes, it is typical that they keep a log at the jail.
He would have to be totally psychotic and just lied straight to my face. And he got very emotional, Rei Davis did, when he talked about Richard Allen and his belief that Richard Allen is innocent based upon his conversations. And Rei's very clear too. On the other hand, he said, I don't know if what Keegan Klein told me is true. I don't know if Ron Logan told me is true. I can only report to you and to any investigator that might come my way what those guys told me. That's all that I can do. But his own opinion is that those guys were involved and that Richard Allen is innocent. And he gets very emotional talking about it. He's not like crying like tears, but gets choked up.
Well, let's try to vet that out. I mean, he's in. So like the first time he comes at anybody saying that Ron Logan has confessed to him is like a month after the crime took place, right? We're talking March of 2017. Does he have access to like how much could he possibly know about a case that no one knew anything about, because the only thing that they released was the Bridge Guy video? And I don't even know if that was out yet. I think
it was a little later. I don't remember the exact month that Ron was at Newcastle, Ron Logan. I don't know the exact month. It might have been a little later, but it doesn't matter, because what you just said, Bob, is true. There was not enough information out there. And that whatever
predates the Franks. Right?
It does predates the Franks. Now it will be, I think, if this is ever investigated. Why? By the way, how hard is it, even now, even if the letters never made it there? I'm coming out here as an officer. I am, and still have to tell the truth. And this is stuff that was told to me. Why is there no investigator going out and talking to Rei Davis right now? Now, I don't know that I trust. It's like kind of like when they went and talked to one of the other third-party suspects whose name was mentioned earlier.
I think they'd be fired if they continue to investigate. And they basically
gave him a kiss on the lips as it was detective. I can't think of his name, but when I asked them to investigate further on the Odinism, and they brought in one of these third-party suspects to be interviewed, I believe it was on August the 23rd of 2023. They basically were saying, "I'm sorry, we're here. We're just doing this because we just have to do our job." They didn't ask any questions about Elvis Fields. They didn't ask any questions about the former wife that made some talked about incriminating statements that this person made. They didn't ask any of those questions. And you have to wonder, why is that? Why did they not? They had him there. They didn't ask him any. How do you know? Do you know Elvis Fields? Do you know him? They didn't ask any rough questions. And so when I say, why don't they go talk to Rei Davis? Part of me is like, well, what difference does it make? Because they're going to go, if they go there, they're going to,
they twist his words up and
they're going to try to work in a way that helps their case out, rather than trying to get to the truth, which is what we should be trying to do.
Right. So why, can you tell people, why is it that you need to still be filing things right now, like motions to preserve and things like that?
Sure. I mean, once this gets up into the Court of Appeals level, and Stacy Uliana and Mark Lehman take over, you are a little bit more, or a lot more, restricted in what you can file at the trial level. In fact, you can't file anything at the trial level. Everything has to be filed at the appellate level. So, now is our time. I mean, we have to file a motion to preserve right now. I'm not saying you can't do that at the appellate level. I just don't know if that probably can be done, but I don't know for sure. All I know is right now, I'm the lawyer on this case, along with Jennifer and Brad. And if I'm going to preserve evidence, I need to do it now. And so that's why that was filed. And, and the motion to correct errors is kind of an extension. After the sentencing, we filed the motion to correct errors, because that's basically, for those who don't know, that's trying to give the judge an opportunity to forego an appeal and a long appellate process, expensive appellate process, and say, hey, I, the judge, made a mistake, or some mistakes here. Or there's new stuff out there that should cause a new trial to occur. And that's what we filed the motion to correct errors for. I mean, we understand it's a crazy long shot, but it's the right thing to do, and to shore up the record as well. And plus, just if on the off chance, it's going to take 18 months to 2 years for this appeal to go through. So you want to make sure that you do everything you can to get back into court as quickly as possible.
And in your motion to preserve, did you also ask for leave to amend your motion to correct errors once that evidence is produced, should it be produced?
I didn't. I was talking to some bigger brains than I am about whether that's a feasible thing to do legally, and that's being debated and talked about behind the scenes.
Your statute's kind of like you've got X number of days,
Yeah.
period. But you would think if something newly discovered came out, that it might buy you some more time. But yeah, you got to ask all those other brains. And why do you think McCleland might have, if assuming that he's aware of the letters, never produced them, why do you think McCleland would do that?
If he was aware and he didn't produce them, I mean, there's an obvious answer to that. But I don't want to think the worst of people, even though he's said a lot of bad stuff about me. And I guess he could say the same thing that he thinks that I've said about him. The difference is I back up everything that I say with facts. It is a fact that on May 1st, he got exculpatory evidence. It is a fact that he didn't turn it over until September 8th. It is a fact that he told me in an email on September 6th, the ludicrous statement that he doesn't know who the Purdue professor is, and he may never know who it is, when they knew about it in August, that we found out later in a Jerry Holman file from September the 23rd. I mean, and he's never explained that. Why did you tell me that you didn't know who it was, nor that you might not ever be able to know who it is, which is just insane. But, I back up when I say something. I'm not trying. It's really not trying to be personal. I'm trying not to. I mean, at times I probably have been, but I'm really trying to back up everything. Here is a problem. This is what the facts are related to the problem. And now we need to question why this problem exists. Again, mainstream media, podcasters that are taking, listening to McCleland and Holman, and why are you not asking these questions? Start asking these questions, for crying out loud.
Well, the murder sheet are their shills for the state. That's why they don't ask any questions. But here's the good news, Andy. So this is what I'm
not going to comment about them. I don't know. I don't know.
Yeah.
I don't listen to them either. I don't listen to you. Whatever is going on with whoever's on whoever's side, I just want truth to be told. And I want, some, you are the defense diaries. I'm not expecting to be hit with hard questions, but if you hit me with hard questions, I know you will be fair. So hit me with hard questions if you want to. Okay. It's
for sure. Yeah. So just so you know, I'd be a great cult leader. Okay. And I'm very good at spinning things and manipulation. And I truly don't believe that RA is innocent. I just want to be controversial in clicks. So that's what I've dealt with from the other side for 2 years, where I've been just trying to educate people on due process and constitutionality and fair trials. And it's been, at some point, I would hope that every citizen of this country cares about what is going on with our government. And if you're confused about what the criminal justice system is and what prosecutors and law enforcement are, they are the government. And if you think that they should be able to run amok unchallenged, and that our citizens should just be arrested and then we not have trials and then people just sent to prison, or that the burden is shifted to the defense and we have to start proving our innocence, and the government with all their power and resources and manpower, all those things. The system's built the way that it is for a reason. And the work that you do, which is the real answer as to why you keep doing what you're doing, because you actually care. And I said this about you and Brad, and it was before Jennifer came on. When I would look at you guys from afar and I would tell Allie, and I'm like, this is what two guys that truly believe that their client is innocent, this is what it looks like. This is how hard guys fight. Like when you're booted off the case, you could have, like you said, man, you're laying there in the fetal position. It's like the lowest moment of your career that you've carefully curated over 2 decades and becoming a magnificent trial lawyer and are incredibly well respected by your peers on both sides of the aisle. And to have it all come tumbling down because this dude comes in, somebody that you cared about, somebody that you trusted and betrayed you. And it all comes, and you could have easily just said, you know what, Brad, I hear you. Like, call me the P word all you want, man. But dude, like, I'm good. I'm good. I'm stepping away. But the fact that you didn't speaks volumes. about how much you care about what's
knowing
going
what
on
you were
this
in
case.
for and how it could have, you know.
Ah, man, it's just
Well,
like
there are those that there were. I've heard that there was some rumor going through the internet or something that, you know, Rick Allen wanted to plead guilty, and that because we want to be in the spotlight, we told him no, we're going to trial because we wanted to go to trial so we could be in the media. And that's offensive to me. I mean, it's outrageous, and that never happened. It never would happen. And by the way, if Rick Allen had said that to me, that I am guilty and I want to plead guilty, that would have been a real easy way for us to be done with this case. And I would have been, I wouldn't have been happy that he was guilty and all that if that really were the case. But it would have been a nice way. And there are some lawyers, sadly, there are some lawyers that push their clients toward guilty pleas. Whether the evidence stacks up beyond a reasonable doubt, whether they're guilty or not, they just want to get in and get out. And that's not our job, Bob and Allie, like you guys have been talking about. Our job is to, force the state to prove its case beyond a reasonable doubt and to use the Constitution, for our clients' benefit. But, it has not, there's various points in time in this case where it would have been easy for me to get out of this case when when I was in the fetal position would be one of those times. But what never was going to happen was Richard Allen was never going to plead guilty. That topic never came up. And in any way. And so it's just, that's offensive to me that anybody would say that. And, that would have been one way to get out of the case, though, I guess.
Right. I would just truly hope anyone who's now watched you guys on our lives and heard you speak can't possibly believe that to be true. Not to me, not any rational, logical thinking human being.
Or it's somebody who's being truthful with themselves.
Right.
That isn't so dug into a position that they don't give a shit about the truth. I mean, like the first time I met you, I knew you were salt of the earth. It's like, you can tell when people are salt of the earth. You can tell when people are genuine, and you can tell when people are full of shit. And you're just not that guy, man. All right. So
wait, how are Brad and Jennifer, and are you guys still a united front?
Yeah, that's what I was saying. My buddy Dave Harper had said that, there's a rumor out there that you guys, because he knows I don't watch anything or whatever. And he said, there's a rumor that you guys are all, fighting or at odds with one another. It's just not true. I mean, Brad is busy. I'm busy. Jennifer's busy. I was with Jennifer Saturday, like I said earlier, pouring through crime scene photos and things like that. And Brad still has 2 kids at home, and he's a busy trial lawyer. And I love Brad Rosie. I love Jennifer. I love Matt Hoffman. We'll get the gang back together, hopefully in sooner than 18 months. But yeah, everything's good on that front.
All right. So here's 2 tough questions. And I'm going to end on 2 tough questions. And they are, and I know what our answer is Allie and I. So if it turns out you had all this stuff and it blossoms into an ineffective, what's your position as to your client? I mean, what do you do in that position if it turns into an ineffective assistance counsel claim?
You own it, and you go in and you tell the truth about what you did that was wrong or that you didn't do that you should have done. And you don't, unfortunately, I've seen some lawyers that get very defensive up there, and you don't lie to help your client out, but you don't, I was ineffective. I mean, if you're ineffective, you're ineffective. And if there's things that we should have done that we didn't do, then, you just go up there and own it. What else is there to do? I don't even know what the other option is. So
you lay on the sword. Like Allie and I would lay on the sword. Yeah. Things are going to be missed inevitably in every trial. Sure. And when you're pushed up against a speedy demand, like there are not enough hours in the day for you to look at every single thing and make sure that every single bit, it can't be done unless you have a massive team of lawyers that are all working behind the scenes behind you, and all your paralegals. There's going to be things that are going to be missed. And if the situation comes about and if it's in the best interest for your client, you're going to do what I know that you would do, which is lay on the sword and you say, man, like, God, I wish I would have seen that at the time. I really do.
I don't, is that falling on your sword or just telling the truth?
I think it's like, it's telling the truth, but you're falling on your sword. Cause like you said, Andy, there's a hell of a lot of lawyers out there that'll, instead of doing that, will get super defensive.
Yeah.
Oh yeah. Well, you know, be trying to make up some kind of bullshit instead of just saying, man, you know, like I missed it. Like
I got a number of things in my brain that I, you know, I don't know if it, you know, rises to the level of, you know, whatever would be called ineffective, but you know, any trial lawyer worth his salt is going out and wondering what you could have done differently, what you didn't do, that one piece of thing that you didn't get done or accomplish. And, you know, and then you don't sleep. And then, yeah. So, you know, and it's the same thing right now. You know, what would have been ineffective, Bob, Allie, is not, it's scary to file the stuff that I just filed. Okay. It's scary because because you don't know if it's going to backfire. But if I didn't file it and it ends up being completely accurate, what Rei Davis said in terms of he sent McCleland these letters and I just didn't do anything about it. I just kind of ignored it. Then that's ineffective. And so, you know, but these are the tough decisions that defense lawyers have to make. And I just wish I didn't have to make it. I wish it was easier. It just isn't, and it's never going to be easier. It just
never easy, man.
No, never.
It never is, and it's a calculated risk that you had to take. You had no option,
zero option.
When you're presented with that information, you've got to run with it. Period. And you do what you can on your end of it. You go through the evidence. It's like, is it possible that this guy withheld this shit? Like, because you sit here and you think like what is like if Nick McCleland is consciously hiding this, knowing how many eyes are on this case, he had to know that it was going to come out at some point. So that is a major decision for him to say, you know what, I'm not going to send these letters. So I think you and I both agree that probably the most likely scenario is that McCleland, I think, is going to come out and say, you know what, we had them. They got tossed in a box. I was prepping for trial. I didn't see him. I'm sorry. Yeah. You know, but at the end of the day, in a Brady situation, does that matter? Because what matters is the fact that they didn't get sent. It doesn't matter why.
Yeah, Richard Allen doesn't care about the legality of of what it means.
Right.
He cares that he's sitting in jail, and we could have had that information. And you know what? Let me tell you how good of a guy Rick Allen is. If it is accurate, if it is true that McCleland got this stuff, and let's just say that is true, and that it is in a box, and it's close to trial, and he just didn't look at it, and he comes out and he says, "I'm sorry." If that is what happens, I'm sorry. I feel awful about it. You know what Rick Allen would do? He would accept his apology, because that's the type of human being that Rick Allen is. And I mean that sincerely. I'm not trying to get, you know, whatever. There's probably like 10 people watching right now this late. At least it's, I don't know how this all works, but whoever would be listening, I'm not here to say 35. I'm not saying this for them. I'm saying it because it's true. That's the type of person that Rick is. He would I just know that's how he would react. He'd just say, does he mean that he's really sorry if that's what happened? And
Kathy, on the other hand, would want to punch him in his face.
Kathy's a different story.
I was just going to say, I would not forgive him. And unlike your household, Andy, in our household, I am never wrong, and Bob is never wrong.
Yeah, that's not true. I've wised up over the years, babe. You know that. You have to admit that. Early on in the relationship, I was never wrong. You were never wrong. I'm wrong a lot these days. I am wrong a lot, and legitimately so. Allie's a formidable foe, and one that's very tough to challenge.
What's that second hard question?
All right,
I'm
so
dying
the
to know.
second hard question, and it's a kind of a running theme with kind of the tour that's been going on from the state side and all the interviews I've heard, that that Rick Allen could end this. Why is Rick Allen? Because he clearly wants to apologize to the families, right? I mean, like, we heard that he wrote it down. He wrote it to the warden. I want to apologize for killing the girls. He could end all this. He doesn't need to appeal. Why is he appealing?
Because he's not guilty. Rick Allen is not guilty.
That wasn't a hard question.
Yeah, but you know, I will say I'm still worried that at some point in time, Rick would, because this is the type of guy that he is. He could just say, this is why I ran out after the sentencing. I ran out after him to talk to him and just say, keep your head in this, because I know the type of man that you are, and you would be, you know, you would want to end this and listen to all those people that got up on the stand and said, don't appeal, do the right thing, and all that kind of stuff that was said. And I could see him buying into that and saying, all right, I think it's good. Let the families move on. Let my wife move on. Let everybody move on. And I'll just kind of live the rest of my life in prison. And I still worry about that. But when I went out and told him, I kind of got mad at him and said, don't do that. You're going to disappoint a lot of people that are out there supporting you. And I think he's still surprised that there's all these people that out there that are supporting him. He always, when I tell him, I think there's lots of people, man. I mean, I've been told that there's a lot of people out there supporting you all over the world. And he's just like, why? He doesn't understand, you know, but it does embolden him. It does give him a little bit of an energy lift. And I see it in his face when I tell him that. And I know people that are sending letters and so forth, that I hope that he's getting them. I did get to talk. Jennifer and I talked to Rick earlier this week before he was moved. And unfortunately, he was still at Westville. We could not hear him, but he could only hear us. So I told him, just to it gives you a little insight into my relationship with Rick. It used to be when I told him, you're going to get out, and when you get out, you and I are going to go have a beer together. But then during the trial, I found out how much he loves coffee. He was insane for coffee, and he was insane for, he wanted Taco Bell, but there's not a Taco Bell in Delphi. So I said, when you get out, we're not going to go have a beer. We're going to go have a cup of coffee, or more than a cup, and then we're going to go have Taco Bell. And when we couldn't hear him on the other end, but he was like, yeah, he was excited about that. And then at the end, he got, we told him some personal things that we wanted to talk to about, and he got, he just motioned to his heart. And that's the last thing that I said to him before he got, that Jennifer and I both said to him before he was shipped off.
Yeah, and I've got a favor to ask you, and it's on behalf of my friend Kathy, and I know that you care about her too. I mean, you've got this connection, man. Get her in to see her husband. Like, she's got, like, do what you can, man. Get her in to see him. Like, he needs to see her. She needs to see him. Like, please, may
doesn't make any sense. I'm so confused.
It's crazy. It's crazy. So I'm hoping that you're able to leverage that friendship that you have. And I know that you don't want to keep going and asking, but that's a big ask, but it's an important ask. Like, she's got to be able to see him. And Rick needs it. I'm certain of that.
Thank you for saying that. I mean, it's easy to overlook a lot of different things that are simple like that. Rick loves her more than anything, and and she loves him more than anything, and they need to see each other, and not in the environment of Westville, which was weird. And so,
and a lot of people here have been asking, even local people, Andy, what can we do to help? What can we do? What do you say?
I don't know. I mean, I wish I had some magic answer. I mean, I'd like to think that a letter campaign of some type would help, but there's so many different, which avenue are you going to travel for a letter campaign? Like, hey, local journalists, can you try to get these guys on to explain some, the things that I've been going over ad nauseum about, all the different things that I don't think they're asking. I feel like that is something. I feel like praying is just, it's an important part of my daily life. And I think prayer is powerful and works, and I believe in that. And I know there's a lot of people that just think that's dumb or whatever. And and I respect their opinion, but that I think there's power in that, especially a collective power of everybody. And I think in terms of practical things, now that Rick's in, he's at Pendleton, figuring out how you can send him. He's in a cell. I don't know if he's ever going to be out in general population, but if you send him stuff that he can read every day and just give him encouragement, that would be huge.
At least my understanding is if you're sending to the DOC, and maybe it's not the case in Indiana, a book has to come from Barnes and Noble, or like you can't send a book from your house. I'm not even 100% sure if you can use Amazon. So before anybody mails anything, call and find out what can be mailed, because they don't want people sending like the regular books. You know how easy it is to drop acid into a book, into the actual paper of a book. So they want it to come directly from the.
And he is a reader, by the way. Rick is a reader.
And that is a great thing to send a prisoner who is a reader. That there is almost nothing more valuable than a good book that they can, especially like you're saying with him being a reader.
Yeah, they can leave the walls of the prison through their mind, by reading a great book. So, well, look, man, I know you got to get up early.
Did he tell us what's next?
Yeah, what's next? I mean, what's next?
Well, I'm going to the dentist in the morning. When I was in Florida back in 2023, kind of going through my bad spell after we were kicked off, I was tearing into a packet and this tooth came out broke off. So on October 31st, when we went back in for the hearing, I was like all jacked up from having gone to the dentist. I'm just telling you this, every time I was trying to get this tooth replaced, there was a hearing. March 18th, I was supposed to go. Well, that's the contempt hearing. And then there's another hearing, and it was always that. So tomorrow is the day when at least I'm moving in the right direction. And, because then you're in front of that jury and you're just like, they probably think what's wrong with that lawyer? He's missing a tooth on this side over here. So, but whatever it is, part of who I am at that point in time. And I'm trying to get that fixed tomorrow morning. So immediately that's what's going on next. In terms of Richard Allen, we're waiting for the judge to rule on all of the variety. There's a lot of motions out there that are actually outstanding beyond just the motions that were recently filed, the motion for to correct errors. I think there was a couple of other motions that were filed before that. And so we're waiting on all of those. And then, and then we'll pass it on, presuming that the judge is not going to grant any of our requests. And maybe I'm wrong. I don't want to be so presumptuous. Again, I try to think the best of everything and be optimistic. I'm an optimist by nature, but it just seems like it's natural to think that it's not going to get granted. So then do everything we can to help Stacy and Mark out in their appeal, to give them information and ideas and stuff like that. And then we're also going to, Jennifer and I and Matt and Brad, when he's able and has time, we're all going to continue to ferret out leads and, people calling in. And every time I've found this out now, sadly, after I didn't really pay a whole lot of attention or didn't give a whole lot of credence to the sleuth world out there. But there's a lot of power in the podcasts and in the YouTube people that are out there. And every time I did media and they talked about it, or the local media, we would get information that was important. And a lot of that over the course of the case itself came because of the media out there, the content creators, I think is what they call it, all of you. And thank you. I want to say thank you to all of them, because you guys do amazing work. There might be some people out there that are nuts and all that kind of stuff. I don't know, I don't know what's all out there, but the ones that I know about, that send me things, that people send me stuff, it's really well thought out. Some of it's really amazing in the knowledge base that they have. And they ask really great questions and things that have gotten me thinking about, well, wait a minute. And then I'm going to take this piece and that piece and but they've already done it, and they did it a long time ago. So I want to thank all them, and you guys keep doing your thing. And then we'll keep doing our thing on our end. We'll keep investigating as things pop up. And I'm ready for the media stuff to be over. It's just not natural for me to do this.
You're really good at it, though. So there's that.
Well, I don't know about that. I appreciate it, but
And hopefully you've seen
you're
all
a genuine
the,
guy, that kind of thing, especially on YouTube, because it's long form. It comes out. So,
but hopefully you've seen all the comments.
You've always got to.
Oh, I can't. I put a piece of paper because I don't want to read the comments because I worry that I'll be focused on that, or I might get emotional if there's something nice said. I just, I appreciate a lot
of I love you, Andy's, and thank you, Andy's, and you're
nice.
inspiring me, Andy.
That's nice. I don't say it lightly. I really appreciate it. I appreciate people say I'm praying for you all over. I mean, I'll go to restaurants.
Even got I'm good. Andy is good looking.
Oh, that they need some new glasses. So, but when I go to restaurants or when I'm places and people come by and they'll say, "Hey, I'm praying for you," I tell them the truth. I feel those prayers. I felt those prayers, and I'm sorry to get on that topic, but it's just
and there's been a lot of people saying, God is with you, and talking about your belief in God, your strength in God, and people supporting that, and also giving similar messages. So
I appreciate all that, just everything that everybody's doing out there, and the work that you guys do in spreading the word about trying to get the truth out of this thing. And that's all that we're trying to do, is get truth out there. Whatever Rei Davis said may or may not be true. If Keegan Klein said it may or may not be true. Ron Logan may or may not be true, but we deserve to see those things, and I want to see them. And I hope that it all works out, and there's some easy explanations as to what might be going on, and we don't have to go down some bad road of trying to have, I hope that doesn't happen. I just hope that there's an easy explanation, and we can get the items. That's most important. Then we can start looking at the items and comparing them to crime scene photos and others, and seeing if it's a bunch of hooey or if it's real. And then again, like the Ron Logan tie to Keegan Klein, is that real? And there might be ways to figure that out. And even this podcast or YouTube, whatever you call this, even somebody listening to it might be like, well, wait a minute, I do remember those two guys connecting or something. And I do remember seeing his car. You just don't know where it's going to lead. And then that can help find the truth of what actually happened, as much as we're going to be able to ever find it out. So all this stuff I think helps. But I don't like doing it. I really wanted to get on here. I didn't mean for it to be this long, and I apologize for that. But I really wanted just to be more like, I want to give credit when the Department of Corrections is doing the right thing. I want to give them credit for that. There's a lot of bad actors there in the trial that were revealed during the trial, Gallipo being chief among them, but others as well. Walla being among them as well. But there's, when the good actors are out there, and I don't want to name them, this is how sad it is, guys. Like the guards that watched Rick, that I complimented because they were so nice and humane to him and just really good human beings. I worried that they were going to get in trouble for being nice. I worried about that. Right. And I worried. That's why I'm not going to name the person that's the person that's the contact I have, because she is a very nice person, and sincere as the day is long, and just a great public employee for the Department of Corrections, and makes things happen very quickly. Yet she might be in trouble for being nice and doing her job well, on this case. These are the things I have to worry about, which is what you were talking about, Allie, how weird everything is in this case, so.
All right, my friend.
Thank you, guys.
Thank you.
Have a wonderful day at the dentist tomorrow in that chair. Getting things ripped out of your head, getting posts stuck in, whatever they're going to do.
Fortunately, I think they're just going to check to make sure that when the fake tooth gets screwed in a few weeks, that everything's good to go. So you're going to have to see me with my missing tooth. Whoever you were out there that claimed that, oh, he's not whatever you said, he's attractive. I'm not going to give you my best smile right now, because I don't want you to see what's really going on underneath the smile. So anyway.
All right.
Thank you for your time, and enjoy your evening.
All right. Bye-bye.
Bye-bye.
Yeah. All right. There you go. All right. So let's pound through these documents real quick. Yeah. I heard that big sigh. I heard it. I heard it. Too bad. We're powering through. I commit to something. I stick to it.
Yep.
And we're kind of late on these, so I imagine that most people have probably heard or read most of these, but I want to go through Andy's first, which is going to be it's all this. Oh, big yawn. All right, so this is defendant's verified motion to preserve and produce specific evidence, which was an interesting approach on this. So Richard Allen, by counsel, now comes before the court with his verified motion and moves this court to order the state of Indiana to preserve certain specific evidence and to produce that evidence to the defense in support of the motion. Richard Allen states the following: one, on
And
February.
just to chime in, this is what I was asking Andy. Did you, in conjunction with this motion, asking that they preserve evidence, asking that they produce evidence, did you request that the judge essentially wait to rule and give leave to amend the pending motion to correct errors uh, in case there is new evidence produced to them? And his answer to that was that, there are still it sounds like more appellate type lawyers researching and chiming in that don't necessarily think that that's worthwhile at this point, or maybe they're still investigating. But that was the question that I was posing to him. In conjunction with this, have you already asked the judge to, like, hey, don't rule yet, let's see if we get anything?
Yeah, for sure. So, one, on February 2nd or 12th, rather, 2025, Richard Allen's counsel, Andrew Baldwin, met with inmate Rei Davis at the Newcastle Correctional Facility. Two, during their meeting, Mr. Davis informed Attorney Baldwin of the following: one, that Rei Davis was in the unique position of having met both Keegan Klein and Ron Logan during their stays at Newcastle Correctional Facility. Rei Davis, talked with Ron Logan about the Delphi murders on multiple occasions. Over the course of time, Logan confessed to his involvement in the murders along with two other people. During those conversations, Logan provided certain details of the crime that only the actual killer would know, but never divulged who the other two people involved in the murders were. In or around March 2024, Keegan Klein was placed in the same general area as Rei Davis, and at some point apparently learned that Rei Davis had talked to Ron Logan while Logan was incarcerated in Newcastle. Over time, Klein began questioning Rei Davis as to Rei Davis's conversations with Ron Logan and whether Logan had ever mentioned Keegan Klein's name to Rei Davis during those conversations. Rei Davis began to realize that Klein may have been one of the other members of the crew that Logan described as being involved in the murders. Over time, Keegan Klein began to reveal information about the Delphi murders that corroborated details Ron Logan had revealed to Rei Davis several years earlier. Some of the details Keegan Klein provided to Rei Davis are the types of details that could only be known by someone involved in the killings. These conversations between Rei Davis and Keegan Klein occurred all the way up to the guilty verdict, at which time Klein expressed his relief that Klein, would no longer be a viable suspect in the murders due to Richard Allen's conviction. Not knowing whether Allen could be the third person involved in the murders, Rei Davis asked Keegan Klein whether Mr. Allen was the third person involved in the murders. Klein replied that Richard Allen was not the third person and had nothing to do with the murders. Keegan Klein further revealed to Rei Davis that Klein, and Logan knew each other through the sharing of child pornography that they shared on burner phones, and that further, Klein and Logan, would see each other every 3 to 6 months so that Klein could assist Logan with using the burner phones because Logan was inept working with electronic devices. Rei Davis further explained that once Keegan Klein began revealing his role in the murders sometime in the summer and fall of 2024, before Mr. Allen's October trial, Rei Davis, began sending letters to Nick McCleland, providing many of the details of Rei Davis's conversations with Keegan Klein in 2024 and Ron Logan in 2017. Rei Davis indicated that he believes he sent as many as 8 letters to McCleland's office hereinafter the Davis letters, and presumed that McCleland was sharing the contents of those letters with Richard Allen's defense team. Attorney Baldwin met with Rei Davis on March 27th, 2024, and learned very limited information from Rei Davis who encouraged Baldwin to watch a videotaped interview law enforcement conducted years earlier. At their February 12th, 2025 meeting, Rei Davis further admitted that when attorney Baldwin met with Rei Davis on March 27th of 2024, that he, Rei Davis, did not provide all the details that he knew at the time to attorney Baldwin for two reasons. One, he, Rei Davis, had not heard of the many details that Keegan Klein ultimately provided him, including that Keegan Klein was involved in the crime and that he, Keegan Klein, knew Ron Logan. And two, that at the time he met with attorney Baldwin in 2024, he, Rei Davis, could not be sure whether Richard Allen was one of the other two people that Ron Logan described as also being involved in the murders. Mr. Davis stated that he was guarded during their March 27, 24 meeting with Baldwin because he, Davis, did not necessarily want to assist Richard Allen's defense counsel if he, Richard Allen, was one of the three men that Ron Logan stated was involved in the murders. Now, again, so like that one particular portion right there is a little confusing to me, right? Because he's saying, like, how would that, like, if he finds out? So I guess what he's saying is that he didn't know.
Right. If Richard Allen was one of the three.
Right.
I mean, so he wasn't about to go out on a limb helping his defense attorney before he was
sure
while,
that
while he wasn't sure that, well, Richard Allen could still be one of these people, one of the three.
Right.
So, and just while we're paused, I figured like Jolene sent a super sticker that was, a message for Andy, and I just put it up, on the screen. So whenever the replay crew watches, they see him. And I know Andy's getting, his friends are letting him know some of the things that they see when people say something nice about him. So, it'll still get back to him.
Yeah. Matt Hoffman may or may not be watching. So again, in March, in his March 27, 2024 meeting with Baldwin, Rei Davis told Baldwin that he, Baldwin, could learn the details of what Rei Davis told law enforcement by watching his videotaped interview that law enforcement should have in their possession from when they, law enforcement, interviewed him, Rei Davis, sometime years before. At their February 12th, 2025 meeting, Rei Davis was shocked to learn that Baldwin had never received this videotaped interview. Following his March 27th, 2024 visit with Rei Davis the next day, March 28th at 11:49 p.m., attorney Baldwin emailed both Nick McCleland and Stacey Diener requesting that they turn over law enforcement's videotaped interview of Rei Davis, in which Davis presumably provided the details of Ron Logan's confession on videotape. To date, the prosecution has never provided any videotaped Rei Davis interview to the defense, nor explained why it has not done so, nor stated no such videotape exists and have ignored the request. The approximate 8 letters Rei Davis claims he sent to McCleland in the months leading up to the October 2024 trial would contain multiple layers of exculpatory evidence, which the defense could have used to further its investigation as to whether certain facts contained in those letters could be verified through crime scene photographs, digital data, and a variety of other means. Defense counsel has never seen the Davis letters, nor known of their existence until after the trial, when defense counsel met with Mr. Davis on February 12th of 2025. Also, the prosecutor has never informed the defense counsel of the existence of any such letters.
And just to note, for those of you, Bob, you weren't on, but I was on with Michael Alsbrook. We were going over the state's response, and he's like that. These are facts that aren't in what the defense was provided. And I said, I was going to ask you that because it's not what in the defense wrote out, but you're privy to more of the discovery. Is there something else out there that says all this stuff? And Michael said no. And it's very strange that McCleland is adding additional facts that don't exist in anything the defense is aware of. And then
what,
we
like
find
the
out about
battery
this.
being removed from the
No,
phone?
there was like a couple things.
Yeah, like the battery
the
being
battery
removed.
being removed was one
Right.
of them. There was like a something else too. I can't recall.
My
but-
question the next time Andy talks to Rei Davis, that I would like, what in the world possessed him to send anything to Nick McCleland?
People
Like, out of
just assume-
anybody on the planet, that you're sending something? I mean, like he's obviously thinking, oh, well, like this is smoking gun shit. Like I'm going to send it to the guy that's prosecuting the wrong guy. I'm going to go right to the source.
Right.
I've got evidence that this guy has knowledge that he shouldn't know unless he was there, and this guy's going to do the right thing. I mean, like that's what the answer is going to be.
Obviously.
I mean, in retrospect, I'm sure Rei Davis wishes he had sent it to the defense so that they could have come forward with it.
Well, we
Even if
also don't know what period of time the letters started, because there was this period of time where Rei Davis wasn't particularly going to trust the defense, didn't know where Richard Allen fell with all of this. And
it sounds like
as
all of the
things
letters.
progressed, he changed his, came to firmly believe that Richard Allen is not involved.
It sounds like the letters came well after Richard Allen was arrested. So, like, I mean, they gave a time frame. It was a time frame in 2024. So like up until like during the trial, still sending shit out. Like, hey, man, you getting my letters, bro?
Somebody got the letters, and the
Hey.
prosecution's office is responsible, even if McCleland didn't.
That was
himself.
I was going to ask Andy. I know he wasn't going to disclose it. He's got this independent witness that he says can corroborate that McCleland's office did receive the letters. I forgot to. He wouldn't have disclosed it. I know who it is, but I'm not telling y'all. On the evening of February 12th, 2025, Defense Counsel Baldwin sent an email to Nick McCleland and his in-house investigator, Steve Mullen, requesting they produce both the Davis.
I want you to make clear that's not something you know from the defense.
What do you mean?
That this information that you know.
What difference do it make? Andy could talk to me about whatever he wants to. There's no gag on this case.
I'm just saying that.
What? Like, you don't have to make clear of that anymore. There's no gag on this case. Andy, I'm a lawyer. Andy can talk to me about what Andy and I talk about this case all the time. We throw concepts back and forth all the time. All the time.
Move on.
All the time. Okay. Thank you. I just had to rebuff your weird statement there. Both the Davis letters and any video recording in their possession of an interview with Rei Davis. McCleland's response was vague, non-responsive to the defense request, and did not indicate whether he, McCleland, ever received those letters, nor whether he sent letters to the defense. In other words, McCleland never confirmed or denied the existence of said letters. Neither did he confirm or deny that he provided those aforementioned Rei Davis letters to defense counsel. On February 13th of 2025 at 3:54 p.m., Attorney Baldwin sent another email to Nick McCleland asking straightforward questions. Did you receive multiple letters from Rei Davis as the months leading up to Richard Allen's October 24 trial? And if so, did you turn those letters over to the defense? These should be questions easily answered and quickly answered. If McCleland never received such letters, he should know that the answer immediately. He should know that answer immediately, since Rei Davis claims that Rei Davis, sent the letters directly to Nick McCleland. If McCleland did receive such letters, he should know that answer immediately. Furthermore, if he did receive such letters, he should very quickly be able to identify the dates that he sent those letters to the defense and how he sent them to the defense, i.e., email, e-discovery, etc. As of the time of the filing of this document, McCleland has failed to answer these simple, straightforward questions. The defense has reviewed all e-discovery from March 2024 to the present to determine whether the prosecution provided the Davis letters to the defense to determine if those letters were hidden among other discovery. The defense found no such letters penned by Rei Davis addressed to Nick McCleland in the e-discovery. The defense has reviewed all emails during the applicable time frame to determine whether McCleland ever forwarded an email with attached letters from Rei Davis. No such emails exist. The defense requests that the court order McCleland's office, as well as any law enforcement agency, to preserve any letters from Rei Davis in their possession and, further, to turn them over to the defense immediately. The defense similarly requests that the court order McCleland's office, as well as any law enforcement agency, to preserve any video recording of an interview with Rei Davis in their possession, and further, to turn such video recordings over to the defense immediately. The defense is concerned that without an order from the court, the prosecution and or law enforcement may lose the Davis letters. Oopsies. Oopsie. As well as the videotaped interview of Rei Davis, or that the state of Indiana may refuse to turn them over to the defense. The defense's concern is well-founded based on law enforcement's history in this case of losing evidence as documented before trial,
Nothing
including
unusual there. Nothing to see here.
including claiming that they taped over certain important videotaped interviews. The defense can produce a witness with admissible evidence that in the months before Mr. Allen's trial, the prosecution received some number of letters from Rei Davis and that those letters had been given to the people investigating the case.
Wow.
The defense had a constitutional right to know of the existence of the Davis letters so that the defense could conduct its own investigation concerning the content of those letters, including conducting depositions that would naturally flow from the facts alleged in those letters. Had the defense known of the Davis letters before trial, it could have used those letters to further its investigation, present them to this court at the hearing on October 1, 2024, on third-party suspect culpability, and factored the information contained in those letters into its trial strategy. Had the defense received those letters after the verdict, then the defense could have incorporated those letters into its motion to correct error. So, conclusion, for the foregoing reasons, the defendant respectfully requests that the court order the prosecution and any law enforcement agency, 1, to preserve any letters from Rei Davis in their possession, 2, to immediately turn over to the defense any letters from Rei Davis in their possession, 3, to preserve any video recordings of interviews with Rei Davis in their possession, 4, to immediately turn over to the defense any video recordings of interviews with Rei Davis in their possession, and 5, to preserve all records in whatever form and communications, electronic or other, including emails and text messages pertaining to Rei Davis. Respectfully submitted, Andrew J. Baldwin. All right, so
Nice.
all right, like kind of walk the people through what constitutes Brady and what you need to show. Like what do you need for
I
it
mean,
to rise
it
to a Brady?
it really just needs to be exculpatory. And exculpatory means that it would be helpful to the defense in um during the fact or sentencing phase, in the guilt or sentencing phase. This is clearly helpful to the defense. It actually, even more so, it points to a possible third party culprit, and that is, you know, top of the line, exculpatory, potentially exculpatory information. And it's not only limited to that, it's also limited, it also would encompass things that could lead to exculpatory information, which is what they're arguing here. Give us the letters, let us follow the leads, let us see where it takes us. What does it have? How does it coincide with, align with, you know, the actual evidence in this case? So,
Yeah, and look, I mean, at this point, the ship has sailed as far as the motion to correct errors. I'm certain Osbrook has told me that there's no amending that. So, I mean, this is for down the road. I mean, this is obvious. And again, many times, I'd say a vast majority of the time that most Brady violations rear their ugly head after the fact, after trial, post conviction. It's like if the state has gone so far as to ferret away information so that the defense doesn't get it, it like it has to fall in your lap a lot of times,
yeah.
whether it's through the post conviction relief petition investigation, and that's a lot of times where you'll find it,
Yeah,
and that's where
time goes by, and I think Osbrook actually mentioned this once when we had him on, um, where people forget what they were hiding, as years go by, and then they just turn everything over, forgetting, "Oh, shit, isn't there something that we never turned over?" So, in that sense, sometimes it does just fall in your lap. And I see people asking, Michael, what's the difference between a discovery violation and a Brady violation? Not all discovery is exculpatory, meaning um, helpful to the defense. Obviously, there's other discovery that implicates the defendant, or you know is yeah, implicates the defendant. I mean, that's a discovery violation. That's anything that should be, turned over that involves the investigation, that involves interviewing witnesses, whether it's considered inculpatory, exculpatory, neutral, so that's where you would just have your standard um, discovery violation. And it's still something that would fall on the prosecution, that they've got to comply with the discovery rules. And maybe Michael can speak to Indiana. I know that Illinois' discovery rules basically incorporate Brady principles right into it. So hopefully that answers everyone's question about the difference
Yeah.
between a discovery violation and a Brady violation.
Right. And I mean, the importance of this is it's, because at this point in the litigation, it's chess, right? So like this particular move by Andy, I mean, he had to make the record, because he said it, and you and I would be the same way. Like it's a sphincter tightening moment when you're coming after the state, right? Like, I mean, you're always
Right.
nervous about it.
And you're either openly saying, "Hey, I missed something," or "You scumbags you're hiding something."
Right.
You
And
know?
and it's a nerve-wracking situation because you're sitting there hoping that you've scoured through everything and that you're not missing it, right? Like that moment in time when you're getting ready to hit the send button to e-file it, and because once it's out there, and you hope that you've looked through everything, and we're talking whatever 15, 17 terabytes of information, which I have.
Certain they dug deep, like he said, went through every hidden file before they went,
And
as far as
frankly,
to
like
say it doesn't exist.
yeah, the time frame for the letters is not vast. Like you're not going back to 2017, you're talking about 2024. You know what I mean? So like I feel very confident that they didn't get the letters. So the question is going to become, did Rei Davis actually send the letters? So I just hope, because I mean, McCleland could say, I didn't get shit. This guy's full of shit. Like
Right,
I
but the
would have to.
DOC has a record of the outgoing
Do
mail.
they though? We don't know
They
that.
I mean, every DOC that I've seen, like, that's how people prove that they mailed filings when sometime later, and we
But that
saw
would
it.
be legal mail. You know what I'm saying? Like this is like I don't
I
know
think
what
that might be considered legal mail. You're
he
mailing
would have
something
had
to
to have
the
written legal mail on the outside of it. And he like I think Andy, I asked him that. I'm like, did he send it legal mail? He's like, I don't think so. I think he just sent it. And like I don't know what it is, but I can guarantee you this. If McCleland's been on the phone with some buddies over at the prisons to find out.
Michael's reminding us they've got that witness that says it came in. So the witness is gonna make a denial pretty hard.
Yeah. Yeah, it is. But I mean, everything can be challenged, you know. Because there's actually, because I do know the backstory, but like in my world, there's actually two witnesses. So I don't know.
All right, go on then.
All right, so you're going to read some of this. Speaking of Osbrook, this is the defendant's verified motion to strike the state's response to the motion to correct error.
And if you were here when we had Michael on, he and I spoke some about this, about the missing affidavits, about the state not having a legally sufficient response. So, but I don't have it in front of me, babe.
What?
I didn't like the document to
Here.
read it. If you text it to me. Oh, you can't.
Here,
My phone's dead. So
all right, hold on. Let me see. The texting thing doesn't work for me, girl.
I know.
I've explained this to you.
I could just blow up my screen and read it. All right.
No,
I got it. No, I got it.
You do?
Well, I'm reading it from your screen. So
that's
the
amazing.
defendant.
Well, you're pretty froggy. Pretty froggy.
I'm tired.
Aww.
The defendant, Richard Allen, by
in
counsel.
Florida for all those days. Yeah, exhausting. sitting around by the pool yesterday. It must have been like
that
a
was
really,
one day of your cousin
really
trying to
grueling
like
day. Really grueling day.
one day of your cousin trying to like have some sense of like thinking about something else and relaxing. Otherwise, it was
Babe,
all
I'm
quite
thrilled
emotional.
that you got to lay by a pool. You deserve it.
All right. What happened
Oh,
here?
oopsies. Sorry. Just kidding.
All
I
right.
slipped into a
The
little
defendant,
carrot.
Richard Allen, by counsel, now comes before the court with his verified motion to strike the state's response to the motion to correct error, filed February 4th, 2025. For the reasons that follow, the court should strike the state's response in its entirety from the record. The state's response is unverified and without supporting affidavit. The state's response is unverified and, without supporting affidavits, asserts numerous facts outside the record in violation of Trial Rule 59H2, which provides, quote, if a party opposes a motion to correct errors made under this subdivision, that party has 15 days after service of the moving party's affidavits and motion in which to file opposing affidavits. And it cites an Indiana case for the concept that a motion to correct errors under Trial Rule 59H1, unsupported by affidavits, presents nothing for the court to consider. And I'm going to repeat that again. So they're citing a case, Murrieta versus Romero, a 2023 Indiana appellate court case. A motion to correct error under Trial Rule 59H1, unsupported by affidavits, presents nothing for a court to consider. In particular, on page 2 of the state's response, McCleland alleges, quote, on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant. Herein attached is State's Exhibit 3. That allegation is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. I've got to take a moment because this is reminding me of, and of course, I'll forget what case it was that we were following, where the judge said to the state, wait a minute, are you about to proffer new facts not in the record? Because if so, it was for a Frank's hearing. So it was like sort of similar, but the judge was saying, if you're about to proffer facts to oppose their motion, boom, they're entitled to a hearing. Like, boom. And here, if all their, response doesn't have any, presents nothing to the court, that should entitle them to a hearing. So moving on, the motion states on page 7 and 8 of the state's response, Mr. McCleland alleges the defense received the van video and, quote, any information pertaining to Ron Logan, end quote, included in Mr. Allen's motion to correct error on January 30th, 2024. That allegation, Mr. Richard, oh wait, sorry, that allegation McCleland that allegation McCleland asserts is supported by State's Exhibit 7, a quote discovery release. These allegations are based on facts outside of the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On page 8, the state's response, Mr. McCleland says Rei Davis was interviewed by law enforcement, which he was, as shown by defendants' exhibits 4A, 4B, and 4C. But Mr. McCleland also says Mr. Davis requested a polygraph examination with which he, quote, failed miserably. No exhibit of Mr. Allen's says anything about a polygraph examination. These allegations by Mr. McCleland are based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Similarly, on page 8, the state's response, Mr. McCleland says that Ron Logan told Mr. Davis, quote, he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned them, end quote. Nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Mr. Davis says anything about Logan removing a battery from any phone. Similarly, nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Rei Davis say anything about Logan burning the girls' clothes. These allegations by Mr. McCleland are based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2.
Oh, look at that footnote.
Now let's turn to footnote 1.
Wow. It's a
The
tasty
tip.
footnote.
The tip in the Orion database, Defendant's Exhibit 4A, does recite, quote, Logan told Rei how he burned his clothes in a fire pit and where it was located. Close parenthetical. Also, Defendant's B4 at page 3 burned his clothes in a burn pile. But again, nothing anywhere says anything about Logan confessing to taking a battery out of a phone. While the court might take Mr. McCleland's misstatement of fact about the burning of clothes as a simple mix-up on his part, either McCleland is making up the allegation about Logan removing the battery from the phone out of whole cloth, or he has access to information about Ron Logan's confession to Rei Davis he has not shared with the defense.
Gotcha.
In either event, there is a reason Trial Rule 59H2 requires affidavits in support of a response to a motion to correct error when that response is based on evidence outside the record.
Boy, Andy's really firing away in this one. All right. Also on page
so also on page 8 of the state's response, Mr. McCleland says no evidence places Ron Logan at the scene of the murders. End quote. This allegation by Mr. McCleland is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On page 9 of the state's response, McCleland says Sergeant Cecil was able to observe photos of the phone when it was found. Here and attached to State's Exhibit 9, 10, and 11. Footnote 2.
See that?
The court might want to consider whether to hold Mr. McCleland in direct criminal contempt for publicly filing crime scene photographs the court ordered sealed at Mr. McCleland's own request. And he cites Hopping v. State, a 1994 Indiana case, it looks like Supreme Court, where, as here, the court has firsthand and immediate knowledge of acts demonstrating a clear disregard for its authority, which threatened to undermine the integrity of the judicial process. Summary proceedings for direct criminal contempt are available. Now, just so everybody knows, direct versus indirect is, as it says here, it's happening right before the court's eyes, right in the courtroom. They're personally aware of it, and that's what's happening here. The judge knows what's sealed, knows what the Mr. McCleland is arguing and has filed, and so that's why this argument's being made. They also quote this case for the concept that, quote, the power of Indiana courts to summarily punish for direct criminal contempt, while specified by statutes, rests upon the common law. It is inherent in the courts, end quote. Alternatively, under Indiana Code 3447-3-1 and 3447-3-5, the court might consider issuing a rule to show cause why McCleland should not be held in indirect criminal contempt for his willful violation of an order of this court.
Ooh, gotcha.
Scroll back up.
See that? Man,
yes, you're doing great.
Scrolling.
Doing great.
It's like tech wizardry. That's what that is. Do you remember where you were? You're right here after
yes, I do. Right where the 2 is. Thanks, babe.
Jay.
Right where footnote 2 is.
It's very small, though. I didn't know if you could see that too.
I do. I blew it up on my side. I can't see us. I can just see the. Okay.
Oh, okay.
So The motion goes on to say, in addition to not saying whether Sergeant Cecil actually observed those photographs, this allegation by McCleland is based on facts outside of the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Also on page 9 of the state's response, Mr. McCleland alleges that Sergeant Cecil's testimony that the, quote, log entry, end quote, on LG's phone reflecting the headphone behavior could have been caused by a malfunction due to dirt or water in the headphone jack was based on his knowledge and experience as a forensic phone examiner. Sergeant Cecil's trial testimony about the possible effect of dirt and water in a headphone jack was based entirely on a Google search performed during the break of Mr. Allen's trial. The allegation that Sergeant Cecil's opinion then had anything to do with his knowledge or experience is based on facts outside of the record and unsupported by affidavit or verification in violation of, let's say it all together, Trial Rule
59H2. Gotcha. Okay.
On page 10 of the state's response in subparagraph 4.L, McCleland says, quote, there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage because that kind of damage is not registered in the logs, reports, or extractions by the phone. Whether or not there was phone damage can only be determined by physically examining the phone, ellipses, end quote. Mr. McCleland is not an expert and attempts here to testify as if he were one. This pleading is not his first attempt.
Gotcha.
Dig. Every single allegation of this subparagraph quoted above is based on facts outside of the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. All the allegations above, based on facts outside of the record and unsupported by affidavit or verification, are crucial to the state's response because the absence of a supporting affidavit or verification by Mr. McCleland violates Trial Rule 59H2. The state's response should be stricken in its entirety from the record of this case. In addition to alleging facts outside of the record of the case without supporting affidavit or verification of the facts on its own motion, Mr. McCleland repeatedly misstates the law and therefore misleads the court. On page 2 of the state's response, Mr. McCleland says the statute governing safekeeping orders, Indiana Code 3533-11-1, quote, does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. He repeats this assertion on page 3, saying Judge Diener, saying Judge Diener was, quote, within the jurisdiction, end quote, of the statute, quote, to make a ruling on the safekeeping motion without a hearing, end quote. But this cannot be so because, as set out in Mr. Allen's verified motion to correct error on page 6, under the next section, Indiana State Code 3533-11-2, Mr. Allen had an absolute right to refuse the transfer to the Department of Corrections because then Sheriff Leesenby had only alleged the safekeeping request was to protect Mr. Allen's safety alone. How could Mr. Allen have exercised that statutory right if the court could make the factual finding based on then Sheriff Leesenby's motion alone?
Gotcha.
Footnote 3.
Hello?
Footnote 3.
Oh, it's a big foot. It's a big footy. Oh, it's a short footy. Osbrook loves footnotes, and I love Osbrook's footnotes.
The state's response does not explain how there was even any evidence before Judge Diener from which he could make a factual finding without a hearing to support his safekeeping order because then Sheriff Leesenby's motion was unverified. Wow.
Yeah, pretty good, huh?
Yeah, so the motion proceeds. He could not have, of course, and Mr. McCleland's, quote, interpretation, for lack of a better word, of the statute is completely unsupportable. Footnote 4.
Oh, oops. Sorry, I was in the chat. Oh, here.
So footnote 4 reads, at pages 2 and 3 of the response, without denying that he knew Mr. Allen was represented by Brett Gibson, Mr. McCleland attempts to make much of Mr. Gibson's not having filed an appearance for Mr. Allen. On page 3, for example, the state's response says, quote, as of the filing of the motion for safekeeping, the defendant did not have an attorney of record. This complaint should strike the court as odd because Mr. McCleland appeared at Mr. Allen's initial hearing on October 28th, 2022, and filed the state's verified request to prohibit public access to the court record the same day with no service of that motion on anyone. Of course, even though he knew Mr. Allen was represented by Mr. Gibson. And on November 22nd, 2022, Mr. McCleland both filed his request for what became known as, quote, the gag order, end quote, and appeared for the state at the hearing on his request to prohibit public access to a court record.
I love this part. This part's so good.
But
here.
But Mr. McCleland did not file his own appearance in this case until the next day, November 23rd, 2022, almost a month after he initiated the case. It is apparently enough that anyone knew for a month that Mr. McCleland represented the state without his having an appearance on file, but it is insufficient for Mr. McCleland and then Sheriff Leesenby, at the very least, to have known Mr. Allen was represented by Mr. Gibson, regardless of Mr. Gibson's not having filed an appearance. A somewhat worn saying about glass houses should come to mind.
Or what's, ganders and gooses. All right.
I don't know what's going on with this cough.
That cough, man.
Okay, so the motion goes on to say on page 5 through 6 of the state's response, Mr. McCleland says the presumption of prejudice from United States versus Chronic, quote, is only applied in cases of non-representation throughout the entire case, citing a Seventh Circuit case of Smith v. Brown. Apparently, Mr. McCleland is unacquainted with footnote 25 of Chronic, which unambiguously says, do you want to make a noise, babe?
Gotcha.
Quote, the court has uniformly found constitutional error without any showing of prejudice when counsel was either totally absent or prevented from assisting the accused during a critical stage of the proceeding. Chronic. And Smith v. Brown, the Seventh Circuit case Mr. McCleland relies upon, says nothing different. Quote, in Chronic, the court explained that presuming prejudice would be appropriate in the face of a complete denial of counsel or denied at a critical stage of the litigation. That's quoting that Seventh Circuit Smith, which is citing back to Chronic. It really is not debatable that Mr. McCleland has, at best, misunderstood Chronic. Quote, our recent cases make clear that, contrary to the Court of Appeals conclusion below, denial of counsel at any critical stage of the criminal prosecution is per se constitutional error, quoting United States Supreme Court case Thomas v. Kemp from 1986.
All right, so before you continue on, make the case that a safekeeping hearing is a critical stage.
I don't know. I've discussed it with Michael. I'm not making the case. And we've already been going for too long. You guys go back and look at other lives.
Yeah.
But I definitely have possible, difficulty. I understand the argument that Michael is making with this. I just also see the issues, especially given that the defense filed motions along this vein, like to undo the safekeeping, like attacking the safekeeping order, and the judge did nothing. So you know, I don't know.
But
don't know.
like, don't they have to look at the end result of what happened? Like, how can you say it's not a critical stage if you look at what the end result is, which is Richard Allen in Westville, psychotic and being involuntarily administered Haldol? Like, that's the end result of it. If that's not
I
fucking
know, and I
critical, what
when
is
I had Michael on, I said, "Bob is, like, huge, that this is, like, don't tell me this isn't a critical stage because of the end result." I struggle with it at times, so we will just have to see what the courts do with it.
Wow. So you're saying that the dudes can just run into court, fucking not give notice to any lawyer. We're just gonna do some shit. Don't
No,
worry
I
about it.
don't think they can do that. I just don't know if it is enough to find that a conviction should be overturned on the basis that they were denied counsel at the critical stage. And we're just gonna have to see how it plays out. And again, I'm saying, bear in mind that while represented by counsel, they attempted to attack this multiple times. Although the judge, I don't believe, gave a full, fair. I think there was one hearing, but um, not everything was known at that point, and so I don't think that the judge properly considered everything, but the lawyers had the ability to put it forward. The judge just
Yeah, well, for the record, I love Michael's chronic argument. Just for the record. All right, continue.
if I can remember where I was now. Was it am I on page 6 of the state's response?
Uh I don't think you had gotten to
I
footnote
don't
5
I'm
here.
I'm
Yeah, I think
asking.
yes, you're on
Okay.
page. Do you want me to pick it up for a minute?
We'll just scroll up and make sure we got the sentence, the last. Yes, okay, that is where we are.
Okay. Do you want me to read?
Sure.
Okay, on page 6 of the state's response, Mr. McCleland calls the van video defendant's exhibit 3A, quote, at best, impeachable, sick evidence, end quote. That is not so. Agent Pohl's testimony about a prior inconsistent statement by Brad Weber would have been, quote, merely impeaching, end quote. The van video is substantive evidence of when Brad Weber arrived home in his van. CEG Pritchard v. State, 2004 case, which states proposition under the silent witness theory, video recordings and photographic evidence may be admitted as substantive evidence, according to Carter v. State.
Accord, right.
Accord. And then we got footnote 5, also on page 6. Mr. McCleland says defendant's exhibit 3A, the van video, quote, is in the form of a YouTube link that is not identified as an item of evidence by the Indiana State Police number, and therefore is an improper submission for consideration by the court, end quote. In fact, as Mr. McCleland must know, Mr. Allen properly filed the video file, that is defendant's exhibit 3A, with the court on a thumb drive. Mr. Allen also properly served the state with the exhibit in the same way. The web link was provided in Mr. Allen's motion to correct error simply for ease of viewing by the parties in the court. And Mr. Allen is unaware of any requirement that his exhibits be identified by an Indiana State Police number, especially when the video recording was provided to the defense, again, as Mr. McCleland must know, without such a number.
Wait a second. How dare the defense proffer evidence provided to them by the state without identifying it by some sort of discovery number that was never given or identified as such by the state.
Gotcha. Okay. More importantly, on page 6 of the state's response, Mr. McCleland erroneously asserts that a motion to correct error, quote, only applies to newly discovered evidence, end quote. Actually, Trial Rule 59H, by its own terms, provides for motions to correct error, quote, based upon evidence outside of the record, end quote. Gotcha. The rule says nothing about newly discovered evidence. Gotcha again. Defendant's exhibit 3A, the van video, is evidence outside the record, and Mr. McCleland has no answer to Mr. Allen's claims under Napoo. You think that's Napui or Napoo?
I had this
Napu?
I always called it Nop. So
Give
I
give me the
switched to
phonetic and
Napoo.
the
I
chat,
switched to
Michael.
Napoo after I had Michael on.
Napoo. Okay, let's see. Napuvi, Illinois, 360 US 264. That
Wait, did we get all those footnotes?
yeah,
Oh, okay.
I just read the big one.
Okay.
That from the van video in his possession, one, Mr. McCleland knew or should have known that Brad Weber's testimony, critical to the state's cases presented to the jury, that he arrived home in his van at about 2:30 p.m. on February 13th, 2017, before LG's phone stopped moving at 2:32 p.m. was false. And two, Mr. McCleland did nothing to correct Mr. Weber's testimony. Napoo states the proposition a conviction must fall, quote, when the state, although not soliciting false evidence, allows it to go uncorrected when it appears, end quote. Gotcha. See also Civic v. Hardison or Civic. It is irrelevant whether the defense knew about the false testimony and failed to object or cross-examine the witness, because defendants cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. Gotcha. Cleaned up. He cleaned it up. Everything about Defendant's Exhibit 3A, the van video, applies equally to the Defendant's Exhibit 3E, the FBI subject information sheet for Brad Weber, which shows Mr. Weber's cell phone first began pinging at the family's house at 2:50 p.m. on February 13, 2017. On page 7 of the state's response, Mr. McCleland says the subject information sheet for Mr. Weber is not newly discovered evidence and is, at best, impeachable evidence. Defendant's Exhibit 3A is substantive evidence of when Mr. Weber returned home in his van, and because it was in the state's possession, Mr. McCleland either knew or should have known Mr. Weber's testimony that he returned home about 2:30 was false. And as with the van video, Mr. McCleland did nothing to correct Mr. Weber's false testimony. Gotcha. Footnote 6. Mr. McCleland seems to be under the misimpression that all of his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. This is of a piece with his idea that actual cell phone data showing headphones were plugged into and unplugged from LG's cell phone hours after 2:32 p.m. indicates that data was caused by dirt or water damage, all because that data would otherwise disprove the entire case he presented. And everyone is to assume that case must have actually or accurately portrayed what happened. See state's response at 9, subparagraph 4.
I just want to note, when you have, it says like impeachable SIC, that says to the court that error was in the original.
Right.
'Cause it should be called impeachment, impeaching, so.
Right. Like anytime you'll see sick in like newspaper articles, it's a misspelling typically.
But it's showing that was the way it was in the original.
Correct.
I'm not the one effing
Right.
this up.
I'm not the idiot.
I'm not the idiot. Right.
It's that other guy. Finally, the one affidavit, the one and only affidavit that Mr. McCleland does have supporting the state's response is State's Exhibit 5, executed by Tobe Lazenby. The problem with that is that Lazenby's affidavit directly contradicts, at least twice, his sworn testimony at the safekeeping hearing held on June 15th of 2023. First, in his affidavit, Lazenby says that Mr. Allen was transferred to the White County Jail on October 28th, 2022 because of overcrowding at the Carroll County Jail. State's Exhibit 5 at paragraph 4. At the safekeeping hearing in June of 2023, Lazenby explained Mr. Allen's transfer to the White County Jail as follows. You can be Q, I'll be A.
Okay. And so tell the court what arrangements you made to have him placed in White County.
Just a matter of simply having direct communication with Sheriff Bell Brooks and explaining my concerns of potential safety and security of our facility, and ask him if he could temporarily hold Mr. Allen for us.
Okay. And were you confident that Mr. Brooks and his facility was adequate to hold him on a temporary basis?
At that time, yes.
TR at 16. There
Transcript.
is not a word about overcrowding at the Carroll County Jail being the reason for Mr. Allen's transfer to the White County Jail. In his affidavit,
Are you?
whoa, Mandy getting triggery. Was that you or Mandela?
Mandy.
In his affidavit, Lazenby also says that Judge Diener, quote, at no time gave me legal advice. Oh, this is just tasty. At no time gave me legal advice on the motion pertaining to safekeeping, end quote, states Exhibit 7 at paragraph 7. In the first instance, Lazenby is not competent to say whether Judge Diener gave him legal advice. In the second, Lazenby unambiguously said Judge Diener adjusted the language in Lazenby's safekeeping motion. You be
I got it.
QLBA. All
I
right.
got it. All right. And is that the motion that I've just alluded to that was filed by you, signed by you, and filed back in November of 2022?
Yes, sir.
Did you draft this motion yourself?
Actually, I had presented a similar motion to request, I should say, to the court. And as I recall, the court had actually come up and provided this particular document.
Okay, so let me see if I can ask more direct questions. Did you prepare the motion in your office on a computer, essentially?
Prepared a similar motion to this. Again, the wording was adjusted by the court.
TR at 11. Judge Diener also asked Lazenby to sign the safekeeping motion, which Lazenby did. And that's TR at 12.
Transcript at 12.
So leaving aside the improper ex parte communications between Judge Diener and Lazenby, adjusting the wording of a motion to be filed in his court and on which he would be ruling, obviously constituted both reviewing and drafting a document, which Indiana Judicial Conduct Rule 3.10 prohibits, except when done for family members. And reviewing and adjusting the wording of a motion is most fundamentally the giving of legal advice, which Rule 3.10 also prohibits. See N. Ray Hill, Indiana case 2011, wherein the respondent admits the commission's allegation that his letter advised the couple on the legality and effectiveness of the documents he had reviewed. This constitutes the practice of law by giving legal advice.
Yeah, I'm going to go out on a really long limb here and say that's legal advice. Ain't no if, ands, or buts about it. There's no way around it. It's not gray. It's not shit. It's legal
Ain't
advice.
no mountain high enough. Mr. McCleland solicited then from Mr. Lazenby an affidavit saying Judge Diener had not given Lazenby legal advice when Mr. McCleland knew or have known that was simply not true.
Goddamn liars left and right.
It's not all that different from letting Brad Weber's false testimony go uncorrected. In sum, in violation of Trial Rule 59H2, the crucial facts on which the state's response depends are outside the record and are unsupported by affidavit or even verification of the response itself.
Gotcha. I'm sorry. I just had to throw my own one in there somewhere.
By Mr. McCleland, the state's response also pervasively misstates the law, and therefore misleads the court. Finally, the one affidavit the state did submit in support of its response alleges facts Mr. McCleland knew or should have known are not true. For all of these reasons, all of them, the court should order the state's response stricken from the record. Conclusion. For the foregoing reasons, Mr. Allen respectfully requests this court strike the state's response from the record of this case and either vacate Mr. Allen's convictions or set his motion to correct error for a hearing. Mr. Allen also requests any other appropriate relief. Respectfully submitted, Andrew J. Baldwin, penned by Michael Osbrook. There you go.
Wait, not there you go. Not there you go. Scroll down a little bit.
Oh,
And there is the crucial missing. No, scroll up a little.
Slow down. Slow down.
Lord.
Slow down.
Just stop right there. I affirm on no penalty for perjury. The following representations are true, which is wholly absent from the state's response.
Gotcha.
all right.
All right, people.
Per
we love
usual, Osbrook does amazing work. His footnotes are legendary.
Oh gosh,
Just
what are we
let it-
doing about all these people?
All right,
these
you
wonderful
go relax. I'll do the heavy lifting here, thanking all our beautiful, beautiful humans.
But I want you.
Oh, monkey. I'll be up in a minute. I'll
You're
look through it.
down. You're up.
Oh yeah, whatever. We'll meet in the middle.
Okay, meet you in the middle.
All right,
right.
I love you.
Love you guys. Love you, babe. Bye.
All right, so before I look, I mean, the thing speaks for itself. It's a race ipso thing to me. Like, I mean, the like Osbrook does one thing, he wins, and I don't know what the response. Like, I can't wait. Like, the best thing that could happen to McCleland is that Gull just denies this shit before he has to respond, because he wants no part in responding to that. Them's the rules. Them's the rules. Michael's citing the rules. There's no way around that. So, I mean, concise, stranglehold, deathmatch winner. That's what that thing is right there. All right. I'm going to give you some thank yous because you guys were amazing tonight. Pokey, love you long time. Woohoo, 13 glorious months of being awesome. Thank you, folks. Jennifer Hill, new member. You've been here. You've been member, and you must have had to re-up. Thank you, Jennifer. Idiot Wind gifted 10 Defense Diary podcast memberships. Thank you so much, Idiot Wind. True Seeker, new member. I seen you. I know you. I be seeing you. Welcome back. And thank you. Passenger 33. Thank you very much. That $5 holla. Appreciate that. So much. Velociraptor RN Michelle. Love it. That was my Velociraptor. I don't, it's like a C plus maybe. Thanks for being a class act, Andy, right? Guy's the best, man. Really is. Thank you so much for that, Velociraptor. Gen X Girl Lawyer, $10 holla. Appreciate you, Gen X Girl Lawyer. You rock. Dark Willow, $5 holla. Thank you for all you bring us. You are so amazing and have the best guests. Thank you, Dark Willow. You are amazing. Thank you very, very, very much for your generosity. April Nunya Business, $5 holla. Thank you, Bob and Allie, for staying on Delphi. Dude, I'm never leaving Delphi. Like, I'll never leave Delphi. Thank you, Andy B, for continuing to fight for Rick. Thank you, April, for your generosity. Carrie M, $10 holla, Mr. Baldwin. And he, like, I don't know, like we found out that he had a piece of paper with tape on it so he wouldn't be distracted by the stuff. So, but, like, I'll make sure that he knows all the love that you guys were kicking his way. Because Andy feels all of it. Like, he's he feels things deeply. Like, Andy's one of those lawyers that cares, So we're very much cut from the same cloth, Andrew Baldwin and I. Mr. Baldwin, I want to personally tell you that you have inspired me. I think Allie read this one, and have made me pay attention to our government, local, state, and federal. Scales of justice are not balanced, and only the truth can fix it. Here. Is that Allie or is that Mandy? Who's firing? One of them's firing on me. She's still complaining and she's not even on the live. Kenda Ducote. Oh, hey, you're muted. You're muted. Wow. Mandy, where are you on the you're muted thing? Bob, you're muted.
I was saying I wasn't
Bob,
supposed to
you're
be
muted.
adding myself back. I don't know
Bob,
if
you're
Mandy added me or if I accidentally added me.
I don't
just
know.
sitting
I
in
hope
the-
Mandy did.
I
She
was
caught
sitting
ya.
in the wings, just mocking you and
Wow.
trying to hurry you up with my mind.
Wow.
And
Jedi.
babe, do you
Yeah.
see there's one clue in this little chat message that tells you who wrote it?
Which one?
The one on the screen.
Allie, I see another at
Right.
this
So
rate.
see how it says Allie :
Oh, yeah.
that means I wrote it.
Oh, so I mean, you're saying Mandy can't type out Allie and put a colon on it
Well, why would she?
just to fuck with me?
All right,
Just
I'm
to
leaving
show
now.
some tech wizardry? Okay.
I still would like to know if I inadvertently added myself or if Mandy just threw me to the wolves like that.
I mean, wolves had been thrown.
Bye.
Love you.
Love you.
Kenda, thank you for that $5 how. Thanks for always staying the course on this case. I ain't going nowhere. No one's ever bullying me out of the case. You kidding me? Take a much bigger bully than those two. I'll tell you that right now. Idiot Wind. Ooh, 10 pound. I love it. Thank you, Idiot Wind. Logo. Can't see what that is, but I love it. What is it? I'm blind. Humble token of gratitude for your dedication and zeal, and hope you give us in this what feels like an impossible sitch. Thanks. You're here. Satsbritches, love it. Andy, I'm a native Hoosier. I grew up near Delphi. What can citizens do to help? I think he tried to answer that. Thank you, Satsbritches. Appreciate it. Indy Cindy, member for 2 months. I think they lied to RD when they said they were giving him a lie detector test. Lied to him like they were giving him a polygraph. No proof. Even if they did, it's not proof of anything. Exactly. Oh, our girl, Lisa Shelton. Lisa, I actually asked her question. The only reason I had to put it up because it was huge and it was going to block Andy's face. I was feeling super guilty about blocking Andy's face with some of the longer supers. Lisa, thank you for that $20 holla. Do you think the state will respond or dump it on Gull's desk to be ignored? I mean, if I'm Nick, I'm hoping that she comes down with an order tomorrow denying all of it. And that's what Nick's doing to the judge from afar. Thanks, Judge Gull. How much time does it usually give a response? I think Andy said like 30. Andy, it speaks volumes to your character that you are still helping and checking on Rick. Agreed. Thank you, Lisa. You're awesome, always. Jennifer Hoff, is the evidence safe? Should we worry they'll get the phone wet or ditch the untested hairs with RAs, etc.? Who has the evidence? Trustworthy location. So that, Jennifer, that's a great question. It's one of the motions that's still pending. They filed, I don't know if you guys recall, they filed a motion to preserve evidence. Gull denied it, firing back, saying that it wasn't specific enough. They're like, all of it. We want all of it. Just preserve all of it, please. Thank you. So we'll see. Like the answer, who knows, Jennifer? I mean, I wish, like in a normal case, I would think that it would be safe. I mean, there's got to be hell to pay. Shit starts going missing. It's got to be hell to pay. Holly Joe Armstrong, thank you so much for that $5 holla. Ina Malcolmson, 5 British pound. Frank, honesty over Golduggery. Thank you, Allie and Bob, for all the information and the great interview with the amazing Andrew Baldwin. Thank you for your generosity. Idiot Win back again with 5 more pound British. Prayer for justice, truth, and justice logo. Thank you, idiot. I agree. Truth. Let's get the truth. Jennifer, $2 holla. Heard RA was moved. Andy's thoughts on location. They're happy. Pendleton's better. Heard it's still kind of a dump. I mean, it's prison, but it's better than Westville. Thank you for that, Jennifer. Erica, member for 8 months. Love you, Andy. You are an angel. Erica, you're an angel. Thank you for being a member for 8 months. Charm free, $5 holla. Heart, purple in nature. Grim Reaper, thank you, Charm. Grim Reaper, what about the witness you mentioned in the latest filing? I forgot to ask him, but he wasn't going to tell anyway. Dr. Von Decay, the lovely and brilliant Dr. Von Decay. To quote Andy Baldwin, God is in this story. End quote. Thank you, Dr. Vonda. I want to say Mosaic. Hope I didn't butcher that. $5 holla. I love Allie. Me too, bro. Me too. Thank you for your generosity. D's Creative Hand Crochet. $5 holla. You are appreciated. So are you, D. So are you. Thank you. Thank you. Thank you. You're cheeky. You're cheeky wee shite. Thank you, Bob and Allie. Andy, you're amazing. Keep up the fight. That's another British £5. Love it. Thank you. Lisa's back. Do you think Gull would have been forced to consider this a nexus if the info had been presented at this time? Or do you think nothing would have moved her? Such a great question. I don't know. Like, I mean, Ron Logan, the girls were found on his property. How was that not a... If that's not a nexus, I don't know what is. It's like, oh, then it would be, well, okay, so they were found on his property, but you don't have his DNA on the girl. It's like she wants the case to be solved. That's her nexus. It seems to me to be her concept of a nexus is that the case is solved by the defense. Oh, you solved it. There's it. There's a nexus. There's a nexus. Yeah, go ahead, bring it in. I was like, oh my God, what? Like, okay, just dismiss the charges. They solved the case. Let them go. Like, but there's never a situation wherein, under that set of circumstances, a third-party culprit defense could ever be heard at trial because there would be no trial because they've solved it and they proved it was not somebody. Like, it's a circular thing that just never ends. It's crazy. So I don't know, Elise. I really don't. I mean, like, she would have had to hear it. It would have been more, I mean, it would have been more ammo for the appeal, if she denied it. I mean, they got it on record. That's why this is so important. That's why these filings, that's why the motion to correct error was so critical. That's why everything that they've been filing is so critical. It's part of the appellate record. Thank you for your constant support, Lisa. I really do appreciate it. You too, Dr. Von Decay. Gifted 10 DD memberships. I'm sure all the benefactors were very grateful as well. Thank you so much. Afton coming in hot with 5 DD podcast memberships. Thank you, Afton. Always givers, both of yous. Ruff and Rabia. I wonder if that is Bob and Rabia. It'd be cool. Rabia's been reaching out. She wants to get involved. I'm trying to figure it out how we can get her in. She's a grinder. She grinds. Gotta love that. Ruff and Robbie, $5 holla. Well, can we be sure that the 8 were sent to McCleland? It sounds like from what we've heard, yes, they were definitely sent to McCleland. That's just my devil's advocate brain taking charge. I mean, it's good. We need to always think devil's advocate. I mean, it's like Osbrook always says. It's like, the first thing he's always doing, he's trying to figure out, how they're going to attack it. Like, before he even moves on. Like, he's all right, how are they going to, it's like he's vetting stuff out. He's like, but okay, how are they going to attack it? They being the government. You got a devil's advocate on these things. Thank you, Ruff and Rabia. Dark Willow gifted 1 DD podcast membership. Thank you, Dark. Look at you coming in, gifting. Aw, Kasha gifted 10 DD podcast memberships. Thank you. Thank you, my lovely and wonderful mod. Julie Melvin. Good to see you, girl. I love you, Andy. You're an obedient man of God. And he will say to you, quote, in my son, I am well pleased. Matthew 3:17. Stay strong and lean on God always. Never give up. He won't. Thank you so much, Julie. Low light recovery. So if Reese is telling the truth and the hand of God is in this, what is the best possibility for Rick? New trial. New trial. That's it. So overturned is a new trial. So if they overturn it, they kick it back to the trial court. the state then has to make the decision if they're going to retry it, which of course they will. So I hope that's, the question is going to become, and God, I hope that the Gull's bias is addressed in the appeal. Like, I don't know if it's still an issue that is preserved because the Supreme Court kind of weighed in on it. I don't know. I mean, the thought of this thing going back in front of her is not appealing. Thank you so much, Low Light. Snarky Sass Angel, $5 holla. Love Andy Baldwin. Truth wins. Winning. Agreed. Thank you, Snarky. Hank's Nightmares through 5 Pre-Karen Reed, Wisconsin. Got a lot of letters there, bro. $10 holla. Dear Mr. Baldwin, just wanted to share Andrea B had some encouraging thoughts from Chile last night. Yes, she did. I love that live. I love when she's walking around Chile. It's got the camera all right in her face. Yeah, I mean, it's Brady shit, and it's one of those things where, like, Andy knows if McCleland comes up with some shit. Oh yeah, I emailed these to him on March 28th of 24. Andy's gonna have to, then it slips into ineffective stuff. That's why I asked him the question. I mean, if shit's missed and it hurt your client, you fall on the sword. You own it. But if it's straight up Brady, head should roll. Tammy, thank you so much for that $10 holla. Tammy Martin, hide and seek with Discovery in Carroll County, no doubt. Thank you so much for that $10 holla. Simone K, 1977. What's up, girl? My son surrenders. I'm assuming that supposed to be suffers from Tourette's and addiction. Inability to not snitch on his own bad behavior is real. Lying to get high is different. No doubt. Docs will concur. I agree completely. Sleuthy, I think we threw that up, Sleuth. And Sleuthy, yes, I did hear he did say Sleuthy. I'll tell you off why. You'll like it. Julie Melvin, $20 holla. When I met with Andy after his long drive to Fort Wayne last March, he was somber, concerned at the premise that Gull's evil ways would end them in jail. He prayed with his mother the whole way. Beautiful man. He really is. Guy's just a wonderful dude. He's just a genuinely really nice guy. Really is. Thank you, Julie. And he was concerned that Gull was going to toss him. Crazy. Low light recovery, $10 holla. The third party perps were at Unite the Right days before Ellie lost their interviews. A few days later, FBI directors said over 1,000 white supremacist domestic terror investigations were ongoing. Coincidence? Mayhaps, mayhaps not. Food for thought, either way. Thank you for your delicious $10 holla. Jen, you're amazing. Love it when Andy's available to spend time with us. Me too. Bob and Allie, you are amazing. No, Jen, you are. Thank you so much for your incredible generosity there. Thank you. 100 times over. Dr. Vonda K, $20 holla. Andy, what can we do? Is there anything that you can think of that we can do to assist? I mean, look, if this thing gets kicked back and there's another trial, they are going to have to really come up with money for experts. Like, I'm talking, I mean, you see the difference in terms of what they're able to do in Karen Reed with the money. I mean, she's raised damn near maybe in excess of $700,000. It's all going towards experts and costs, because that's how much it costs to beat the state in this country. It should scare the shit out of you. Like, honestly. I mean, this whole, like, Government, go government. Oh, what? Fuck out of here. Sean, thank you, Dr. Vonda. $20. Here's a video with detailed satellite images notating a white truck. This is from 2001, research 2017 through 2017. Andy, we fight with you for justice. I'm a local, but no longer afraid. You go, Shauna King. Speak your truth. We need you. We need people coming forward. It's the only way the truth's coming out, or whatever, like Andy said, whatever version of the truth we can get. You know? Thank you so much for your generosity, Shauna. Charlotte, watching from the West Coast. We have a former NBC investigative journalist who wants to speak with Andy. Hopefully we can make that happen, Bob. Hit me up. You know, girl. You're in my DMs. You're in my DMs. We'll make it happen. Heather Brown. And thank you, by the way, for your generosity, Charlotte. Heather Brown, member for 3 months. You all restore my faith in humanity. Thank you, Heather. Thank you, thank you, thank you. Chelsea, member for 7 months. We love Andy. We do love Andy. It's good people. Thank you so much. Living on Love, $5. Why is Gull still able to keep the exhibits and such from the public despite the trial being over? It's a great question and one I do not know the answer to. She does know they are not in fact her property, I hope. It's a legit question. It's crazy. Like the exhibits. Like and it's like they've sealed the pictures. So, all right, you sealed those, release everything else. It's great. Like all this stuff that they do like this just makes you suspicious. It's almost like I don't know. I'm done trying to like work my mind around it. It makes no sense to me. Icy Cat, thank you so much for that $5 holla, Icy. Or Living on Love. Member 4 months. This is number 100 best show you have done. Wow. Thanks, Icy. I like that. Thank you for being a member. T-Dub, aka Cecil, member for 12 months. Long timer. Love that. Wow, 12 months exactly. Appreciate you, T-Dub. Dr. Vonda, per Andy Kopsa. When Monica visited him, she told him, quote, Rick, this is bigger than you. And it is. Yeah. I mean, I'm trying to get my friends, and when I say trying, I'm scheduling. I'm going to get, like, I don't know if you guys have ever listened to the podcast, LA Not So Confidential. Those two are brilliant forensic psychologists, and they do a great show. And I know they dug into Walla on an episode, and I'm going to get them over here. So we can get some expertise from two people that I really, really respect in the field, Dr. Shiloh and Dr. Scott. They're phenomenal. So I keep hitting them up, and then we keep saying, well, let's do it. And then we both flake and start doing other shit. So, but I'm going to follow up with them. But thank you, Dr. Bonda. Julie Melvin, Andy, please give our love to Rick and Kathy and tell him not to give up. God is with them. Stay strong. Thank you so much, Julie. And I certainly always pass the messages on to Kathy. I text her pretty frequently. So I always tell her. And she's keeping an eye on things. Trust me. Like Kathy's not sitting there in a fetal position. She's fired up. She's watching stuff. She's digging. She's up for the fight. I'll tell you that. Carrie M, $5 holla. And thank you again, Julie. Andy, please tell Kathy and Rick they have more support than they can fathom and that we love and care about them. How can we send money to Kathy or Rick? Kathy's rejected it. Andrea had hit me up. She's like, look, my people want to send dough. I went straight to Kathy. She's like, nope. She just doesn't want to deal with the blowback of people sending her money from anybody. She just doesn't want to hear the shit. What she said specifically, and this is verbatim, this is a direct quote from Kathy Allen. She's like, if people want to donate to a charity that's working or an organization that's working on prison reform. That's a direct quote. Kraken, a real booty, member for 10 months. I have global press reach. Andy, can I email you? I'll make it happen, Kraken. I'll send you his email. And And thank you for being a member for all those months. Carrie M, the Indiana Doc website has all the rules for mail. That's where you send the goodies, send the letters, the books. The books are good. Thank you, Carrie. Appreciate you. Dark Willow Andy, you have the courage of your convictions. That's rare. Thank you for staying strong. I think he saw that one before he jutted, but thank you, Dark. And I'll pay, I tell him, obviously our crew is super supportive. So I don't know. How were the trolls out there today? Were they brutal? Not too bad. I mean, what are they saying? What is it what is their pushback on this shit? Jolene, sorry, I almost busted in the song. Jolene, $20 holla. Keep fighting for the truth, Andy. So grateful for you. So grateful for you, Jolene. Thank you. Jennifer, address to write, RA and Kathy to send a book. He's at Pendleton. So if you just Google Pendleton and you go on to the DOC or Indiana Department of Corrections website, he's at Pendleton. That's where he's at. You got to get his inmate number, and then they'll give you kind of instructions on how to mail anything to him. Anybody can mail him letters. Anybody. Jessica Gilman, $5 holla. Oh, and thank you again, Jennifer. So even an inmate has the assumption that the prosecutor would share the info with the defense. I mean, I think the bigger answer to that is exactly what we said in the live. He is under the impression that he's going right to the source. He's going to the guy who's prosecuting an innocent man in his mind. He's like, hey, dude, you're prosecuting this guy, but here's proof that you got the wrong dude. That's what he's thinking. I mean, it makes sense. Therapist nerd, $5 holiday. I want to send him Man's Search for Meaning by Viktor Frankl. Can I please get info for how to send? Hopefully I just gave it to you, therapist. That's it. All right. I made it through. Woo! I did it. You guys were amazing tonight. We were 2 grand strong. Appreciate you guys so much. Thank you for being here. Please make sure that you like it on the way out. Make sure you sub to our channel. We love growing. We're so close to 40. We're 2,200, maybe something like that. 2,200 away from 40. We think we have a good show. I think we figured out why we don't get into the algorithm. When we had put all our straight up audio podcasts and we put them as podcasts, somehow they got put into videos as well. And then when we went in to look at the metrics on those, people come to YouTube expecting video. So when they clicked on it and there was no video and it was just the static straight dope picture, you'd see 9 seconds gone. So, which is telling the algorithm, all right, this content sucks. People drop off after 9 seconds. So we're hoping that along with y'all spreading the word, subbing if you like what you see, because we love the community we built. We really, really do. You guys are everything. It's amazing. I wish I got the crowds for stuff other than Delphi. I know we are the Delphi folks, but our other content's really good too. You should check it. You got to figure if it's this good on Delphi, it's probably going to be pretty good on the other shit too. I'm a boots on the ground guy. I'm going to be for the Jamie Snow thing, but I'm actually not going for Jamie's. I'll be there for the appellate arguments next month. I'm actually going for another guy that I'm going to start telling you about. I'm trying desperately to convince Lauren to have this be our next case. And it's something I'm covering one way or another, but I'm really hoping I can convince Lauren. It's a crazy case, and I think the guy's innocent. So, all right. So yeah, so please share, subscribe, and like on the way out, because that really does help get us out. If you're on Replay Crew, please leave a comment in there, like it. And you guys are amazing. Thank you so much, 100 times over. Just so you guys know, I think we're going to cover Reed tomorrow. I don't know how we're going to do it. Going up against Melanie is insane. She's the Reed equivalent of us to Delphi. So like maybe, and Allie's always like, well, I don't want to go. I'm going to tell Allie she should probably go on with Mel because I know there's a hearing. I don't know that it's a real substantive hearing tomorrow. But I can tell you for a fact, Runkle of the Bailey, he's coming Thursday over to our show. We're going to hang. We're going to talk Reed. We're going to talk Delphi. It's going to be great. He's awesome. If you've never seen Runkle, you're going to love him. It's Canadian brethren, fellow defense attorney, loves guns. I got to get Runkle on a couple of times. I got a gun dude who's just convinced that he can completely disprove the whole bullet thing. So, and I need Runkle for that. Runkle will guide us through. So I'll make sure you're checking your notifications. I'll let you guys know what time Runkle's going to come on. I'm going to do it early. We went late tonight, later than I usually like to go because of the travel. So, but you guys are amazing. Thank you so much for hanging with us. I hope you enjoyed the interview with Andy. I hope it was informative. I hope you took something from it because we're always trying to do that. Because without you guys, I am just an old man talking about a whole bunch of cases. Talk to you tomorrow. Bye.